My lord, in respect of item number 20 and 21, they are tagged matter, my lord. In
2021.
in item number 20, we have
Yes.
filed an IA for implement. It should have come for orders. May I pray that immediately after order matters, this matter may be taken up, my lord?
Okay. You're for the applicant?
I am for the applicant.
Applicant petitioner.
Yes,
Okay.
I'm applying.
Mayor Pidology. But I pray for listing of a writ petition in the motion call Lordship. Case was filed yesterday, Lordship. Matter relates to Lordship in such a junior teacher has been given the charge, Lordship. Although I am the senior most teacher, Lordship. Tomorrow, Lordship, the motion call. Oblige.
Lordship, regarding item number 18, would like to adjourn the matter. And
18?
18, yes.
Yes, you are appearing for which party?
Guwahati University.
Guwahati University. Have you informed the other side? Anyone?
I am for the petitioner.
Any objection?
My lord, on personal ground, I cannot object, my lord, and that may be fixed, my lord. Petitioner is not getting retirement benefits since 2019, my lord.
What is the difficulty? Why are you seeking adjournment today?
Personal difficulty, Lordship.
Huh?
Personal difficulty.
Personal difficulty. It's very wide, personal difficulty. You may be going sightseeing and saying personal difficulty. Huh? After 1 week, 2 weeks? 2 weeks.
That may be fixed, my lord.
All right. Mr. Who's appearing?
P.K. Goswami.
Dr. P.K. Goswami.
Yes.
Dr. P.K. Goswami, no. A mention has been made on behalf of Mr.
RC alum on behalf of PJ Fukan.
Mr. P.J. Fukan, Learned Standing Counsel, Guwahati University, to the effect that he has some personal difficulty to conduct the case today, and therefore the matter may be adjourned for 2 weeks. So Dr. P.K. Goswami, Learned Counsel appearing for the petitioner, has no objection, but submits that a date may be fixed. We'll stop in view of above. The matter be listed on so and so after 2 weeks. November.
May I please, Your Lordship?
Yes.
With the consent of other side, I beg to mention item number 14. It may be listed after 1 week. We have received the affidavit only yesterday, so we'll file the reply.
You want to file reply?
Reply. They have filed the affidavit yesterday, government side.
You want to file reply?
Reply, yeah. 1 week time
After
may be
1 week
given.
time, as paid for by the Learned Counsel for the petitioner, a week's time is granted to file reply affidavit to the affidavit of opposition filed by the state, filed by the respondents. Item 14.
Oblige.
For withdrawal item 24 of the supplementary list.
Yes, why do you want to withdraw?
We withdraw with liberty, Lordship.
Why?
Because certain subsequent development are there in this matter.
Like,
The SARS memo recently provided for petitioner to the petitioner.
what?
SARS memo provided to the petitioner.
Charge memo.
SARS memo.
Okay.
So some new documents are there. So
Your good names?
S. Ahmed.
Mr. S. Ahmed, Learned Counsel for the petitioner, submits that since there are certain developments in the matter, he would like to incorporate the same in the writ petition. He therefore submits that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. S. Das,
Obliged, Lordship.
SC Higher Education has no objection. Next, in view of above, writ petition stands disposed of as withdrawn with liberty to file afresh.
Yes, obliged, Lordship.
Daily list item 1 for motion.
Alright, in this case, my lord, we had little handicap today, my lord. Actually, on last occasion, although I have received a copy, my lord, the record from the court, my lord. Thereafter, my lord, this matter was entrusted to Mr. A.R. Tahvildar. However, today, due to some medical emergency, he is not been able to attend court today, my lord. So if I pray, my lord, let the petitioner.
So you decide who is going to appear. Last time you made a submission that you want some time.
Yes.
Today you're saying Mr. Tahvildar will appear.
Last time, my lord, I took the record from the court, my lord. Record was actually.
So your duty was only to take the record, not to prepare for hearing. Who will appear? Tell me.
My lord, AR Tabular will appear, my lord.
Huh?
AR Tabular will appear.
Tahvildar will appear.
Yes,
Are
ma'am.
you sure?
Yes, my lord. My lord, today,
Are
my
you-
lord,
Huh.
I am praying that let the petitioner be heard today, and we may be allowed to.
It doesn't work that way with me.
We may be allowed to submit.
We'll
to
forget
petition
what we heard today and next day also again we start from stage one.
tomorrow, my lord, tomorrow.
Tomorrow.
No, let the petitioner be heard today and our part be heard tomorrow. my lord. Only that much.
Ken Chaudhary, what do
accommodation.
you say?
That I can do.
No, I don't intend to
Piecemeal,
hear
no
in
piecemeal.
piecemeal. No piecemeal. We hear it completed.
Then
So
tomorrow, my
then
lord,
Huh?
we have no difficulty.
Only on next day, don't come up with that such plea, huh? We also come prepared. Today is, let it be on 6th of November, my lord.
All right. Mr. S. Das, Learned Counsel, Learned SC, Higher Education. Appearing for the State Department submits that Mr. A.R. Tahvildar will be conducting the case. And since he has some personal difficulties, he prays for another date. Mr. Ken Chaudhary, Learned Senior Counsel, appears for the petitioner and has no objection to the prayer. Next para, as agreed to, that the matter be listed on 6th, isn't it?
6th of November.
6th November for admission, for motion hearing.
Yes.
This is in the motion stage.
Actually, my lord, at the motion stage itself, the matter was heard, CAV, then it was in the cold storage, then after
Alright.
again the matter has come up.
Okay, just motion, no hearing, just add for motion.
Item 2,
Yes.
I've received the instruction, my lord.
What is it?
He has not furnished the annexer with the form B, my lord. Specimen signature and identification mark. That is why, my lord. In fact, the principal of the school have tried to contact him also, my lord, but unable to.
But where is the communication addressed to him? How did they try to contact him?
The subsequent communication, my lord.
No, any communication addressed to him or copy given to him?
It is there, my lord.
It is there means where? See, you're saying that that form B is not filled up properly,
Yes, my lord.
but you have to inform him that you come and fill up form B.
That was done by the principal, my lord.
By which communication?
Well, I'll show you. Alright. Communication is not enclosed with this communication, my lord.
So it's easy to say that the form B is not filled up properly. But you have to show that it was given to the he or she has not filled up. That is what we want.
Yes. Well,
See, same submission was made last time also on 22/9. Ms. P. Das, Learned Standing Council, Secondary Education Department submits that respondent number 5, Inspector of Schools, Nalbari, has been asked to submit particulars of the GPF account of the petitioner in Form B by the director, and the same is awaited. So, Inspector of Schools, Nalbari, has he communicated to the petitioner or to the principal?
the principal has written the letter to the inspector of school on 4/10,
Saying what?
saying, my lord, with reference to service, I have the honor to inform that Sri Amarendra Sharma had retired from service on 31/12/2017 as assistant teacher of so-and-so school. He had been received all pensionary benefit except GPF final withdrawal. It is to be stated that through register post form B had been received on 24/12/2024 from Amarendra Sharma. In this connection, it is personal marks of identification and specimen signature format are required to be enclosed with the form, but these documents are not available with the form. I tried to contact with him, but he is not available and could not contact with him to submit the required documents due to proper address so that the proposal can be submitted to the higher authority for further process. Also, he retired on so and I had joined as principal on the school on 30/7/2021. The teacher is not known to me or physically not seen him and could not recognize his signature because he never come to school after his retirement and nobody able to give information about his address.
So madam, why don't you go to the school and do the needful?
Much, yeah,
All
yes,
right.
Lord, yes, your lordship.
Please write. On 22/9/22/25, comma, court passed the following order. Please abstract this last order. Okay? Stop. Next para. Today, Mr. N.J. Khatania, learned SC
Secondary division.
Secondary Education, submits that as per the instructions received by him, the rectified Form B has not been received by the director
Yes,
till
ma'am.
date,
By the inspector of school.
by the inspector of schools to the director of secondary education.
Yes. From the principal of the school.
The principal.
From the
Okay.
principal.
The inspector of schools, Nalbari, is it?
Nobody, my lord.
Has not received the rectified Form B from the principal of the
Borbak Kalak.
Borbak Kalak High Secondary School, Kalak. And that the principal appears to have not been able to communicate the same to the petitioner. Stop. Miss, your good name?
B.H. Shirin.
Miss B.H. Name is shown here?
Yes, your lordship.
Jane or Shane?
Shirin, Shirin.
Okay. Miss B.H. Shirin, learned counsel appearing for the petitioner, submits that she may be given some time to approach the school principal for doing the needful. Stop. Accordingly, let the matter be listed again. Where is this place? Kalak,
It's a Nalbari, my lord. It's
Nalbari. And how far?
it's 55 kilometers.
We listed again after 2 weeks.
Yes, my lord.
All right. The petitioner shall appear before the principal of the school and submit and fill up the form and fill up the particulars in Form B as per the requirement. All right. That copy of that instruction, is it necessary?
No, not necessarily.
Not necessary.
Not necessary. Once he approach the principal, my lord, he will do the needful, my lord.
All right.
My lord, I appear for the respondent number 418.
Okay. Mr.
B. Sharma.
B. Sharma appears for respondent number 4. And Ms. K. Pugan appears for respondent number 1 and 2.
Much obliged, your lordship.
That was, I think,
May I please, your lords?
2, isn't it?
এক number.
Oh.
Yes.
Lordship, the petitioner is under your lordship Samagra Shiksha Yojana Assam, your lordship, is presently holding the post of district program officer, your lordship. Now, your lordship, his grievance is that, your lordship, he all along been, your lordship, complying with the orders of the higher authority, your lordship. Your lordship will, if comes to page 17, your lordship, ekhone na? Bisho, etu put some number.
What, this is a transfer
Transfer.
case?
Your lordship, he 1 year back, if your lordship comes to page 17, your lordship,
This is the impugned transfer order.
yes, not impugned, your lordship.
Okay.
The transfer order, your lordship, passed
Serial
the,
number?
Serial number 14, page 18, your lordship. Are you too good, sir?
Hmm.
Your lordship will find, your lordship, that I was transferred from Sonitpur to district program, as a district program officer, your lordship, at Goalpara, your lordship. Now, if your lordship comes back to page 17, your lordship,
Hmm.
at serial number 16, your lordship will find the private respondent was, your lordship, transferred from Goalpara to Dhubri, your lordship.
Serial number?
6, your lordship.
Okay. Respondent number
4, your lordship.
is transferred from Golpara.
Goalpara
Dhubri.
to Dhubri, and I was brought in this place from. Now, all of a sudden, your lordship, I have just settled down there, your lordship.
What is the date of this order?
This was dated, your lordship. Your lordship will kindly come to
23/9.
23/9/2024. And then your lordship, impugn order is, your lordship, at page 19.
Yes.
Now, your lordship will find that they say that in the interest of public service and for smooth implementation of SS activities, Anupam Sharma, DPO, that is the respondent number 6, Dhuburi is hereby transferred and posted at SSA Goalpara district in the same capacity. Raman Medhi, DPO Goalpara district, hereby transferred SSA Dhuburi district in the same capacity. Now, your lordship, this is not in the public interest, your lordship. First of all, the person who was 1 year back, your lordship, transferred to Goalpara, in whose place I was brought in, he, just to accommodate him again in Goalpara, this order has been passed, your lordship. Your lordship has seen, your lordship, that there is a series of, your lordship, order passed 1 year back, your lordship. After that, your lordship, all of a sudden, when I have settled down in Goalpara, your lordship, I have 18 months of service left, your lordship. They have passed this, your lordship.
You were in Sonitpur, transferred to Golpara. Now
Goalpara,
you are sent
then
to Dhubri.
Goalpara to Dhubri, your lordship, and in Goalpara, your lordship, the private respondent, your lordship, who was earlier in Goalpara, your lordship, he was again brought in, your lordship. My grievance is this, your lordship. This is not in public interest, your lordship. I have 18 years of service left. I have just settled down in Goalpara, your lordship. All of a sudden, your lordship, just to accommodate this private respondent, this transfer has been issued, your lordship. I have, your lordship, submitted representation before the authorities also, your lordship, at page 20. And I have still not been released from service, your lordship. Your lordship may call for the record and your lordship may see what prompted them to pass this order, your lordship. What public interest is involved in this, your lordship?
What
When
is the nature of duty of district program officer?
your lordship, we need to, your lordship, that your lordship will, I am not only district program officer, your lordship, teachers training. Teachers training and pedagogy, your lordship. We need to, your lordship, look after the training of teachers, your lordship. Your lordship will kindly come to page 19. Your lordship will find DPO, district program officer, TT and P. Teachers training and pedagogy.
And
Pedagogy, your lordship.
pedagogy.
Pedagogy.
What is
It's
that?
a knowledge, your lordship. Yeah.
Your transfer was to Sonitpur, or to Golpara
Lordship.
on
1 year back, 23/9.
24.
And your lordship, I was brought in place of respondent number 4. He was sent to Dhubri. Now what they are doing, your lordship, I was sent to Dhubri and he was brought back to Goalpara, your lordship. An earlier transfer order, your lordship, I have not objected to it, your lordship. I have complied, we have joined. And I have not even filed any representation saying that I should be transferred back to somewhere else, Sonitpur again.
This will be a bench 2 matter or bench 3
Bench
matter?
2, your lordship.
Bench two.
Samagro Suksha education, your lordship.
Okay. All right, who's appearing?
I am for the respondent number 1, my lord, Commissioner.
Who is that?
Commissioner
Commissioner-
Secretary Elementary Education, my lord. The
Elementary.
order passed by the Mission Director Sarva Shiksha, my lord.
Do they have a standing council?
Yes, my lord.
Who is that?
Mr. S.
You have not served copy?
Yes, your lordship, we have, sir.
Then why they not appearing? Give me the second file. Where's the acknowledgement? This was
Number-
mentioned yesterday.
Yes, your lordship.
Acknowledgement.
SC in cause list, your lordship, SC SSA was there, your lordship.
Where's your statement that you're still there?
Lordship. Para 13, your lordship. That the petitioner beg to state that petitioner has a prima facie case as has not yet been released from his present place of posting, and as such he is the balance of convenience is in favor of the petitioner in favor of passing an interim order.
What is the transfer policy?
Lordship, there is no such policy as such, your lordship, but your lordship, from time to time, your lordship, they, your lordship, in time to time, your lordship, they issue transfer orders so far as these district program officers are concerned.
There is you're not covered by the state government's
No,
transfer
no,
policy.
that is not, I am not, we are not covered, your
I
lordship,
see.
we are not covered. This is under a scheme, your lordship, central sponsor scheme.
Heard Mr. S. Botakur, learned counsel for the petitioner, who submits that the petition is agreed with the order dated 16/10/2025, by which he has been transferred and posted as SSA Dhubri. He has transferred and posted as
District program officer.
district program officer bracket TTNP in Dhubri. Despite the fact that, did I give you the date? Date, white order dated 16/10/2025.
Lordship.
Despite the fact that the petitioner was posted as district program officer bracket TTNP Golpara. Hardly 1 year back on 23/9/2024. Stop, he submits that the impugn order of transfer is not in. It is appears only to be to transfer and post the respondent number 4. Who is also a district program officer bracket TTNP in Golpara. Next para, the learned counsel also submits that the petitioner has not yet been released from his present place of posting in Golpara. And therefore, pending consideration of the matter, the impugn transfer order may be stayed. Stop, in this connection, the learned counsel refers to paragraph number 13 of the writ petition. Next para, issue notice of motion returnable by 4th of November. Oh, you were there.
My lord,
When can you Huh?
My lord, we'll have our instructions, my lord.
When?
My lord, 3-4 days may be given to us, my lord.
Okay, then will returnable by 29th?
My lord. My lord, may I pray for considering the interim on the next date, my lord? Let us have our instructions, my lord.
You have your instructions? No problem. We'll have it on 28th, returnable by 28th October 2025. Also issue notice on the interim prayer. Returnable by the same date. Mr.
H. Barua, my lord.
H. Barua, Learned SC, SSA.
On behalf of Mr. B. Gogoi, my lord,
Okay.
SSA.
Learned Counsel appears and accepts notice on behalf of Mr. B. Gogoi, SC, SSA, who will represent respondent numbers
2 and 3, my lord.
2 and 3. And Mr.
B Taluka.
B. Taluga,
Or
accepts
respondent number
notice
one.
on behalf of respondent number 1. Petitioner to furnish requisite copies of the writ petition to the learned counsels appearing today within 2 days. Petitioner shall take steps for service of notice upon respondent number 4 by registered post with ADD. Within 2 days.
Lordship. Today itself.
Hmm.
Till then, your lordship,
Having regard to the projection made, it is hereby provided that till the next date, status quo be maintained.
lords. Did you like?
Yes, my lord.
For orders, item 13.
My lord, item 13, na, Vedo?
13.
My lord, they have provincialized my order, my service, my lord.
Hmm.
By order, it is 16 October 25.
Hmm.
But only thing is that order was 9/5/2025, but they have provincialized now, my lord. Then I have to silence. Order of this honorable court has been passed on 9/5/22. But they have provincialized my service with effect from 16/10/25.
Please write down, Mr. M.R. Khandakar, learned counsel for the petitioner, submits that in compliance of the court's direction, the respondent Director of Elementary Education has passed an order dated 16/10/2025, provincializing the service of the petitioner with effect from the said date. With prospective effect, no, with effect from 16/10/2025. Stop, he submits that the direction of the court was for provincialization of service of the petitioner from which date?
9/5/2022.
9/5/2020. Stop. Next para, considering the no, not same, cancel that, same paragraph. In support of his submission, the learned counsel has produced order dated 16/10/2025, which shall be kept on record and marked as X for identification. Next para, in view of above. The order of the court having been complied with, the contempt petition stands closed. Gustav, however, it would be open for the petitioner to agitate with regard to the effective date of provincialization by taking recourse to appropriate process and as may be permissible in law. Mr.
I'm representing both the contender, my lord.
Mr.
NJ Khatun.
Anja Khatanier, learned counsel appears for all the respondents.
I'm the.
15 and 16.
Meet with the lawsuit, kindly pass over the for the time being lawsuit.
ৰাজনীতি তোমালোকৰ ইমান কি সদায় কেছটো আহিলেই তোমালোকে টাইম লোৱা দিছ বা
Time being for the time.
they are enjoying a stay order and whenever the matter is listed they have some difficulty.
After some time lawsuit, my senior
My
PJ Soikia's
submission is this stay order should be vacated, let them time for 3 years, I don't mind.
lawsuit, senior counsel Mr. PJ Soikia's is on legs.
Someday it is in Imphal, the other day, every time whenever the case is listed, the telephone call will come from their side. Well, this person very unfortunate, my lord, he is not even selected by virtue of a stay order and enjoying the hearing.
The Chaudhary will have it after some time.
No,
Yeah.
here,
I'm here.
Oh.
I'm sorry, Miller, I couldn't be present. I was on leg in other.
Yes, what is the matter?
Lordship, may take up the WPC number 5584/2023. But two matters are connected, my lord.
And is a single petitioner, is the same petitioner.
Same petitioner, my lord.
Why two writ petitions?
Two writ petition, my lord, during the course of, my lord, hearing of the other writ petition. My lord, and record was produced before this court. And there it appeared that the state selection, my lord, board has prepared, my lord, this, my lord, the result of the, my lord, selection, which was, my lord, made by the school selection committee. In that writ petition, I had challenged the, my lord, the appointment of the respondent number 6, as well as, my lord, I have asked that the ground that this school selection board, the award, the marks that has been awarded are not correct. So therefore, my lord, due to this subsequent event of, my lord, state selection board selection, I have impugned in the next writ petition.
So which one will go to take
As
up?
on today, the list, the result that was prepared by the school selection committee does not exist. Now the state, the result prepared by the state selection committee exists.
So which one do we take up?
My lord,
5584.
well, I'll be referring to both, but your lordship may, I'll be referring, my lord, for different annexures to the other writ petition as well, my lord. Lordship may take up, my lord, this 5584 of
Alright.
2023.
Just give me a brief
Lordship,
background.
my lord. My lord, what happened here, my lord?
What?
Lordship, may kindly note down few of the dates, my lord. My lord, this post in question is the post of principal of the Bamundongra Higher Secondary School that was advertised on 35/2019. 35/2019 post was, my lord, advertised. And the last date of submission of application was 7/6/2016. An interview held and the school selection committee has prepared the, my lord, panel list, including the result, on 15/6/2019.
Fifteen 6/2019, what happened? Interview plus?
Interview held and this panel list was prepared. They have evaluated marks, my lord, received by each of the candidate.
Why such a long gap?
My lord, in fact, what happened after the advertisement, on coming to know the illegality committed by the state selection, the school selection board, I have submitted a representation before the authority that the parameters, in fact, my lord, the entire selection is governed by, my lord,
No, Mr. Saikia, just a minute.
Okay.
The advertisement date is 35/2019.
35/2019.
19. Then
30th.
last date?
Last date is 7/6/2019.
19. Okay.
19.
Then interview held on?
Then, my lord,
Interview held on 15/6/19?
15/6/19.
Okay.
Thereafter, my lord, I have submitted a representation that the marks, those have been, my lord, granted by the school selection board in respect of the private respondent are illegal because they are not entitled to that, my lord.
Mm.
And that representation was not disposed of. So therefore, I have approached this honorable court by filing a writ petition, my lord, WPC number 7980 of 2019. That writ petition was disposed of on 6/12/2019 by directing the authorities to expedite the process, finalize the process, taking into account the representation that has been filed by me and the steps taken thereon.
6/9/2019,
6/12/2019.
12. Then,
Well, after this order, the respondent authority, they have appointed me as the principal.
Hmm. Then-
And that was challenged by the private respondent in WPC number 3558 of 2021.
respondent number,
Respondent number 6, my lord. Sajal Kumar Das.
what is the case number?
Lordship will find this order is at page
Case number, the 244.
3558 of 2021.
3558.
Of 2021.
Yeah.
Challenging my appointment order dated 29/7/2021.
Hmm. Okay, then,
Then this was disposed of by order dated 11/8/2021.
Hmm.
And my lord, in that writ petition, my order was passed without considering the variation in the marks. Rather, the respondent authority came to a conclusion that the B.Ed degree obtained by the private respondent
Hmm.
is not recognized.
Hmm.
Then this court, while disposing of this writ petition,
Hmm.
has observed that the earlier judgment of this court has said, even if it is not recognized, if an application is filed by the concerned school on a prior to a particular date, in
Hmm.
that case also that can be taken into consideration as recognized. So therefore, the direction was issued to the respondent authority to
Hmm.
call for the records of that particular college where from he has done the B.Ed
Hmm.
and scrutinize entire matter. And if it is found that his order would be in favor of the private respondent number 6, that his B.Ed degree is recognized, in that case, issue notice to both the parties. And after hearing the rival submissions, you pass a necessary order. That order, your lordship will find at page 37. Lordship will. Oh, my lord, sorry, my lord, this order is in the other writ petition, my lord. Sorry. Sir. Lordship, may I kindly take up the other writ, it's only for the purpose of this order, my lord. That will be page 37 of 37 of the other writ petition, my lord. 4883. 4843.
Hmm.
My lord will come to, my lord, page 41. page 41.
Yes.
Lordship, may come to paragraph 13.
Hmm.
From the said point of view, we deem it appropriate to remand the matter back to the approving authority in the government under section 13(5) of the Act of 2003 to verify from the record as to whether the Borpeta BT College had made its application for recognition to the NCT prior to 18/8/1997 or subsequent to it as provided in the judgment of the court in Parimita Sharma Supra. The appropriate authority shall specifically call for the records from the Borpeta BT School as well as from the NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before the NCT. Depending upon the materials that may be available, appropriate order may be passed. If the order passed by the approving authority in the government is in favor of the petitioner for the purpose of other consequential action that would be required to be taken, both the writ petitioner and the respondent number 6 would be given an opportunity of hearing to put across their respective cases till the approving authority takes its decision, and thereafter the consequential actions are taken. The respondent number 6, the principal of the Bamundogra Higher Secondary School shall continue to remain as such. If further continuation would depend on the logical outcome of the process as indicated above. Now, pursuant to this, at page 43 of the same writ petition, 4883, an order has been passed.
Hmm.
On 29/4/2023. But this order is also there in the other writ petition. Lordship may take up the other one as well. So here, my lord, what they have come to a conclusion that the B.Ed degree obtained by him was recognized.
Whose B.Ed degree? The private respondent.
Private respondents. But thereafter, my claim, so far as the direction was that opportunity to be given to both the parties to hear the rival claim of the parties and then pass the consequential order. First, you decide whether the degree is recognized. Lordship, may kindly once again, my lord, page 41.
See, just a minute, Mr. Saikia,
Lordship,
let us go in sequence.
Lordship.
What was the first writ petition filed?
My lord, first writ petition was filed WPC number
7980
of 2019.
So where do I get the order?
Yeah, Lordship will get this order, my lord. Page 29 of the other writ petition, my lord. That is 4883. Page 29.
This was by you.
This was filed by me. This is prior to, my lord, because after the interview, they did not act on it. I have submitted a representation alleging that the person, respondent number 6, is not entitled to the marks as, my lord, contemplated by the notification. Now here the direction is at page 13. 31.
Hmm.
Page 31.
Yes.
In view of the above, writ petition is disposed of directing the respondent authorities to do the needful to complete the process of selection for appointment to the post of principal Bamundogra High School, Borpeta, as per rule, and also by taking into consideration the aforesaid letter dated 22/8/2019, Annexure 3, as expeditiously as possible, preferably within a period of 2 months from the date of receipt of a certified copy of the order. But till then, my lord, the question of whether his degree is recognized or not, that has not come into picture.
So your letter was for re-examination of the proposal.
Lordship,
And that is on the basis of the recognition, whether it is recognized or
No,
not.
no, that is on the basis of my objection with regard to the allotment of marks.
Marks.
Allotment of marks.
Okay,
It is not, I am not on the B.Ed degree, whether it is recognized or not.
okay.
The government of their own volition, while after this order has been passed, they have passed an order, my lord,
Hmm.
appointing me as the principal, my lord, without going into the marks of received by each of the party. Rather, they have only confined to the ground that the B.Ed degree obtained by the respondent number 6 is not recognized.
So your representation was basically on the marks.
On marks, my lord.
Yeah, according to you, you have scored higher.
I scored higher, man. This is my lord, evident. I'll be taking your lordship, my lord. This is-
All right, then after that, what happened?
Now, after that, my lord, they have appointed me, my lord.
Where's the appointment order?
My lord, appointment order is order dated 29/7/21.
Page?
Free.
It is page 33 in WPC number 4883.
4883.
Lordship,
Oh, you have to settle with from the both the thing. 4883.
4843, my lord, 4843. Page 33.
Page 33.
Page 33.
All right.
On the recommendation of the State Selection Board,
Hmm.
Assam, and pursuant to the government approval accorded by so-and-so, and subject to reversion without any notice and without assigning any reason thereof, Major Ali, that is petitioner, a postgraduate teacher of Rahabari Higher Secondary School, District Borpata, is hereby appointed as principal on regular basis and posted at Bamundongra Higher Secondary School, District Borpata, against the existing vacant post so-and-so, so-and-so. Well, this was challenged by them, my lord. This was challenged by them in WPC number 3558. Challenged by the private respondent.
3558,
Lordship, my lord. At page 37 is the order,
37.
Lordship,
Mhm.
of the same petition.
Yes.
Now, Lordship, may come to page 41.
What was the ground for challenging your appointment?
My lord, ground, my lord, was not known, but then, my lord, the affidavit that has been filed, it is the ground that his B.Ed degree is recognized, is not recognized.
Your B.Ed degree?
His B.Ed degree.
No, you're appointed.
Lordship, my lord.
They were aggrieved, they challenged. On what ground?
My lord, that was challenged, my lord, the grounds. But then, my lord, but I'll have to go to 3558%. In the writ petition, my lord, the government has filed an affidavit that his case cannot be considered because his B.Ed degree is not recognized. So the court has confined only to the extent of, my lord, whether the B.Ed degree of the respondent number 6 is recognized or not.
You were placed at serial number 2.
Yes.
The private respondent in the present case was at serial number 1.
Lordship,
then
That is the ground, but then in the affidavit, they said because his case could not be considered because his B.Ed degree is not recognized. So therefore, though he was selected as one, this is as per the school selection the board's result also.
B.Ed degree, your B.Ed degree or the respondent number six?
Respondent
Okay.
six.
So that aspect of the matter was not taken into consideration.
Regarding marks, etc., because if his my lord, B.Ed degree is not recognized, in that case, whether he is in serial number one or not doesn't make into my lord,
No, not regarding marks. It was regarding
only
B.Ed degree.
B.Ed degree.
So, then verify the records and admit his applicant recognition is prior to. All for the records, then,
My paragraph 14, the appropriate authority shall specifically call for the records from the Barpeta B.Ed school, college, as well as from the NCT to arrive at a factual satisfaction as to on which date the college made the application for recognition before the NCT. Depending upon the materials that may be available, appropriate order may be passed. So that is whether it is recognized or not. Then, my lord,
no, one thing I don't understand, recognition of the college.
my lord, the degree.
Huh?
My lord,
What is it, what is the connection between having the private respondent not having a recognized B.Ed degree?
because
and
that is one of the requisite, my lord, qualification for the purpose of, my lord, post of principal.
No, that I understand. Please listen to me. The B.Ed degree of the respondent number 6 is put to question. And the other part is recognition whether the college is recognized by NCT prior to so and so date. What is the relevance?
Well, if the college is recognized, the degree will be recognized, my lord. Because the colleges have to, my lord, make an application for recognized before the NCT. So there's a, my lord, a date has been given 18/8/97, my lord.
So B.Ed degree is acquired from which college? Not from this
Barpeta
college.
B.Ed college.
This is
Separate
a college. And the post is of a principal of this college.
No, my lord, ours is under the, my lord, higher secondary education, my lord, the general higher secondary school. And he has obtained the degree from an institute, my lord, which confers, my lord, B.Ed degree. That is Barpeta College. Barpeta, my lord, B.Ed college.
Advertisement was for the post of principal,
Principal of the, my lord, this higher secondary school.
higher secondary school.
One has to obtain a B.Ed degree from a recognized institute.
Okay.
So that particular institute was not recognized or recognized, that was directed to be
Oh, I
decided.
see.
If that
So, okay, I now understand.
Gotcha.
So recognition of that college who gave
college,
the B.Ed
yes,
degree.
who is there.
That is the
If that
okay.
college is recognized, in that case, his degree would be
Okay,
recognized. So now thereafter, my lord, in
So,
paragraph 15, it said,
Uh-huh.
if the order to be passed by the approving authority in the government is in favor of the petitioner, for the purpose of other consequential action that would be required to be taken, both the writ petitioner and the respondent number 6 would be given an opportunity of a hearing to put across their respective cases.
Okay. Thereafter, what happened?
Now, this judgment was passed, my lord, on 11/8/2021.
Pursuant to that, what happened?
Pursuant to that, my lord,
Page 43.
respondent number 6 was appointed, page 43.
Okay.
Here, no evaluation with regard to the marks. It is only they have come to a conclusion that the B.Ed college is recognized. So therefore, his B.Ed degree is recognized. So he is appointed. I have been reverted back. There's no evaluation of the marks of the rival parties. Now, this was challenged by me at page 45.
Just a minute. Where's that finding that it's recognized?
My lord, third paragraph. First compliance, in compliance of the High Court's order dated so-and-so passed in WPC 3558 and order dated passed in contempt of so-and-so, the government passed the order number so-and-so, whereby it is ordered that after careful consideration of the above and approval of competent authority obtained accordingly, it is decided that Sajal Kumar Das may be notified as principal Bamundagra Higher Secondary School. In view of the above, the order number so-and-so dated appointing Majid Ali, postgraduate teacher of Rehabari High School, Borpeta, as regular principal of the Bamunbai High School, Borpeta, is hereby cancelled. In pursuance, the order dated so-and-so in compliance of the High Court order dated so-and-so, Sir Assam passed in contempt case number so-and-so, subject to reversion without any notice and without assigning any reason thereof, Sri Sajal Kumar Das, postgraduate teacher of Bamundagra High School, is hereby appointed as principal on regular basis as passed so-and-so with grade pay of so-and-so. Further,
But Mr. Saikia,
so there's no finding, my lord, that
there's no such
finding, my lord.
indication that this is a B.Ed college
Exactly, my lord.
recognized.
Yes, my lord, that of course, my lord, I did not my lord, notice, my lord. There's no finding, but it has complied. It has only confined whether his B.Ed degree is recognized or not, nor there is any my lord, finding that the marks granted to each of the candidate.
There's no finding, but can you tell me
Look.
whether there's any stand in the affidavit in opposition that this finding was based on so-and-so? Anything like that?
Yes. My lord, I have.
Because court has given certain direction.
Page 62, my lord.
Mr. Saikia, see,
Lordship.
the order dated 11/8/21
Lordship.
in 3558 of 2021
Lordship.
says that the record should be called,
Lordship.
personal hearing should be
Lordship.
given to the parties. And now you're reading an order which says that as per the government's approval,
Government.
so and so should be
So
appointed.
therefore, this court has set aside this order.
No.
This court has set aside this order.
And that is of course,
Lordship,
right.
Lord.
But what I was asking you is that whether anything has been
But in
mentioned in
this-
their affidavit? No.
In this, my lord, is not there, but after setting aside, they have, my lord, again, they have, my lord, taken a decision. After,
Okay.
my lord, this order has
It
been
was set aside by which order?
by order dated, page 45, order dated 19/6/2023,
This is filed by you.
filed by me.
Okay. 2442.
This is 2442 of 2023.
Why was it set aside? On what basis?
My lord will find,
Para 7, please read page 50. 50.
Lordship. my lord. Paragraph 7, I have considered the order dated 9th March 2023. A perusal of the same would indicate that a hearing was conducted by the concerned authority before coming to conclusion with regard.
Just a minute. What is that 9 March? That is not the impugn order. 9 March.
Impugn order was 29/4, my lord.
Correct. So this is what is this 9 March?
9/3, assuming.
Yes. Correct. You see page paragraph 4.
My lord,
9
this-
March is the government
my lord,
notification.
This order. which-
Government decision.
Yes, my lord,
Yes.
page 43, that 9/3/2023, that is reflected, my lord.
Then you can read paragraph 7 now.
Lordship. I have considered the order dated 9th March 23. A perusal of the same would indicate that a hearing was conducted by the concerned authority before coming to a conclusion with regard to the status of B.Ed degree of the present respondent number 6. What was directed by the order dated 11/8/2021 was that concerned authority shall call for the records from the Borpeta BT College as well as from the NCT to arrive at a factual satisfaction as to on what date the college made its application for recognition before the NCT. It was only when the concerned authority is to issue an order in favor of the petitioner therein respondent number 6 in the present writ petition that a hearing would be held with regard to the writ petitioner and the present respondent. This has not been done. Accordingly, the matter is remanded back to the Secretary School Education Department to rehear the petitioner as well as the respondent number 6. On the order that is to be passed by the concerned authority and thereafter pass appropriate order in accordance with law within a period of 2 months from the date of receipt of the copy of the order of this court. Consequently, the order dated 9/3/2023 issued by the Secretary to the Government of Assam Department of School Education is set aside and quashed. While hearing the petitioner and the respondent number 6, the rival claim of both the parties shall be considered. The status quo order passed by this court earlier shall continue till a final decision is made. So, my lord, the court has my lord, presumed that order dated 9/4 being a consequential order of the order dated 9/3/2024, so the main order has been set aside.
So any,
Now, hearing was taken, my lord, I have submitted my objection. Lordship will find at page 53.
no, I'm still in 9/3/23. 9/3/23 is not available here.
It is not available. my lord.
Okay.
It is there.
118, my lord, page number or.
In this writ petition.
It's not there in the.
It's not there in this writ petition.
It is in the 588, my lord, code, other repetition.
118,
5584, my lord.
118.
Mr. Secretary, just a minute.
Lordship.
118.
There are some finding is there that his BA degree was recognized.
9/3 speaks of petitioner having submitted photocopy of NCT letter recognition. That much only.
That was authenticated by the Lordship, that much only.
That much only.
No, my lord, there's a last line. The NCT has authenticated the document pertaining to BEd degree obtained by Sajal Kumar Das by later dated so and so.
Yes, yes.
Now, but still it was remanded back.
It was remanded.
Thereafter it was remanded.
It says that what was directed by the order was that the concerned authority shall call the records from Barpeta BT College as well as NCT to arrive at a factual satisfaction, on which date the college made its application for recognition. This has not been done. So again, remand back. Okay, then
And to take the, my lord, both the parties into, my lord, here both the parties, my lord.
Hmm.
Now, I have filed my objection, my lord. My lord, in fact, by page 52, we were asked to appear. I was asked to appear before the authority.
yes.
And on 53, page 53, I have submitted my objections.
Hmm.
Clearly, my lord, specifying, my lord, all the, my lord, marks where the discrepancies have been, my lord, given. my lord.
Hmm.
Now thereafter, my lord, an order at page 62 has been passed.
In terms of the court's direction,
Court's direction,
19/6/23.
page 62.
Yes.
Yes, sir. So there also, there is no finding with regard to the marks obtained by rival parties, my lord.
Hmm. What was the basis of the decision?
My lord, this was, my lord, a challenge before, in this court in the WPC number 4843, my lord.
But remand was on the basis of that, calling the records. Nothing was mentioned about marks.
Nothing was mentioned. So that is why, my lord, this court has stayed it, my lord, because time and again, this court has, since the beginning, the first order in, my lord, WPC 7980, direction,
Just a minute.
lordship,
This WPC number
this is 2442.
2442. This was your writ petition.
It is my writ petition,
And how was it disposed?
my lord.
By
this-
saying that call for the records, hear the parties.
Yes, yes.
Where is it mentioned that regarding
Yes,
the
yes.
marks should be,
Yes.
Yes.
marks should be verified? Which one is more, which one is less? Anything
sir.
mentioned?
Yes, yes, I'll come to that. my lord. Page 45 is the order, my lord. Page 50, my lord. I have considered the order dated 9th March 23. A perusal of the same would indicate that a hearing was conducted by the concerned authority before coming to conclusion with regard to the status of B.Ed degree of the present respondent number 6. What was directed by the order dated 11/8/2021 was that the concerned authority shall call for the records from the Barbeta B.Ed College as well as from the NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before the NCT. The order further directed that it was only when the concerned authority is to issue an order in favor of the petitioner therein, respondent number 6 in the present writ petition, that a hearing would be held with regard to the writ petitioner and the present respondent. That has not been done. Accordingly, the matter is remanded back. So the hearing is to be taken place after the decision that the B.Ed degree is recognized.
B.Ed degree only.
B.Ed degree.
You're on the marks.
I am on the marks. So therefore, the direction was that both the parties will be heard for the consequential relief. So that hearing was not given. I have submitted my objection also. That is also not taken into consideration. No hearing was also taken.
Mr. Saikia, please understand. The order of the court has gone in this way. Your writ petition saying that B.Ed degree, whether it's correct or not, call the records, notice to NCT,
No,
the parties.
that was his writ petition.
No, this is,
No, 2422 was his case.
My lord,
your name is Majid Ali.
Majid
Yes.
Ali,
so-
3558,
2442,
2442 filed by,
which you just read,
no, that I have challenged his appointment.
which you just read, has
Lordship.
been disposed of
Lordship.
by directing that here the parties on what point? On the B.Ed degree.
No, but I'm sorry, my lord, subject to my lord.
You read paragraph 7, you read
Yes, but-
paragraph 8 also,
yes,
same
yes.
thing.
My lord, yes, my lord, I have considered the order dated 9th March.
No, I've understood what you're trying to say.
Lordship.
You are saying that the point whether I had scored more or he had scored less or whoever, this has not been looked into. And parties have not been heard into on
lord-
this point.
My lord,
But there was no direction as such in this writ petition.
my lord, you kindly see, my lord, prior to this order, the order in 3558 is there, my lord, in writ petition 3558.
It was there, it no longer came to be there in the second writ petition.
My lord, 3558, your lordship will find,
You have not
Based-
filed any other process saying that this order is not complete, that has been left out. Please review or something like that, nothing?
no, my lord, you can see, but 3558 specifically, my lord, this has a, my lord, nexus from the judgment in, my lord, WPC number 7980. Where I have submitted my application saying that he is not entitled to the, I was never, my lord, on the B.Ed degree. I was solely on the, my lord, marks. The B.Ed degree was their own, my lord, finding that his B.Ed degree is not recognized.
There's no dispute about that.
Lordship, my lord.
Only question is that regarding your marks has not been mentioned in this order.
But here,
Yet again, now you agitate that marks has not been looked into.
no, my lord, the hearing is not been taken, and what I have said in the, my lord, what I would be saying in the hearing, that, my lord, I have said, my lord, page 52, my lord.
Anyway, let's proceed. Let's
Lordship.
proceed.
Lordship, my lord.
Page 62, you were reading. 62.
page 62, my lord.
Now, what has happened by this?
My lord, here only they have again confined to the, my lord, B.Ed degree only.
Respondent number 6 has been appointed
Lordship.
now. Which part is that? After verification of roll 63.
The last paragraph, my lord, a hearing held on 11/8/23, compliance of the High Court order dated so and so passed in WPC number so and so. After verification of all relating to records, documents to the B.Ed degree of the petitioner and careful consideration of the above and approval of competent authority obtained accordingly, it is decided that Sri Sajal Kumar Das may be modified as principal, Bamundogra Higher Secondary School. Well, I was never on the, my lord, this B.Ed degree. My whole hearing was that he's been illegally granted marks. That is my case. So
Sajal Kumar Das may be modified, not appointed, modified.
modified. No, subsequently, I think there's an order.
Hmm?
Modified only, my lord.
What is to be modified?
After verification of rating document, B.Ed degree, petitioner careful, the above approval of the computer, it is decided that Sajal Kumar Das may be modified as principal, Bhagavandogra Higher Secondary School.
Hmm. So now, by this, the respondent number 6 has been again put back as principal.
No, there's a stay order. I am still continuing there, my lord.
No, by this order,
Lordship, my lord. He's sought to be put back.
stay
my
is a
lord.
different thing. By
Yes,
this order,
yes.
say he is the principal now.
Lordship, my lord.
Then after this, what happened? You filed this writ petition,
Present writ petition,
present writ petition.
Present
That
writ
is, that is
4883.
4884, no, 4843.
4843 up to 2020. Lordship,
4843. During this pendency, again, you file one more.
Lordship, my lord.
What is the reason?
My lord, while, my lord, this order was, my lord, this hearing was proceeding, the
Mhm.
record was produced. And Lordship will find, my lord, in WPC number 5584,
Yes. What is new there?
I have annexed a order, my lord, at page 54.
54.
Four eight eight three 23. The respondent to file affidavit as may be advised, record produced be retained. Mr. P.J. Saigal and senior counsel for the petitioner may also be allowed to examine the record if so advised. List on so and so for a final consideration in as much as record reveals that both the writ petitioner and the respondents have been awarded 17 marks each. But while the school made the selection, he had received 20 marks, I had received 18 marks in the hands of the school, my lord. Now, this record reveals that both of us been awarded with 17 marks each. And then I have found, my lord, the state selection, my lord, the statement of marks at page 57. Next page, my lord. This is the state selection marks prepared, my lord.
Yes. Where are you? What is your name? Masjid Ali.
I am Majid Ali.
Hmm.
I have been granted 17. He is at serial number 1. He is at 17. Now I am impugning this in this writ petition, madam.
17. So
17. Now he is not entitled to 17. He is rather entitled to 15, madam.
how?
Yes, madam. Because of the, my lord, notification, your lordship will find page 58 of, my lord, this WPC 5584.
Can I just point out one thing?
No, my lord, before, my lord,
I'm just pointing out one.
my friend maybe, my lord.
No, no,
yes, my lord,
I just want
let
to
me
point out
submit, my
one
lord.
thing. Lord.
Let me submit. He doesn't want to go
No,
into the merit. my lord.
No.
He has taken a plea that res judicata, so therefore he want to confine it to that. That I'll
My
come.
lord,
my lord.
Since my learned friend is taking a lot of time, that's why I'm making one prayer. Subject for your lordship's kind consideration. Now, my lord, these subsequent writ petitions are barred by constructive res judicata. Because you cannot file one petition today with 1 point. Tomorrow you cannot find after that dismissal another petition for another point. If you have got several cause of action, you must put it together. Supposing you put a relief which is denied or it's not even considered, then explanation to the CPC says matter it will be deemed to have been refused.
But I'll
Therefore,
reply
you
to it.
cannot. No, that's why.
I'll
My
reply
lord,
to it.
there are only 4 writ petitions, very small facts, my lord. 4 writ petitions. In the second 2422, you have not taken those points. Therefore, you have waived your right. That is my case.
We'll hear you. That's all right.
Yes, my lord. I'll reply to it, my lord.
See, both are 17 marks. How do you say that he should not get 15,
Yes, my lord.
17
That's
marks?
what, my lord.
That is never an issue.
On what basis?
Yes, my lord. My lord will find, my
By
lord,
the way, who's older?
Madam?
Who's the older one?
older.
Age wise, who's older?
I think he's,
He's older.
he's otherwise elder.
I mean, the petitioners,
Lordship,
not you.
even, my lord, they
Oh,
also, I think they were petitioner is younger to.
I think our client will retire in next February or something.
Okay. Okay, anyway, tell me.
Lordship. My lord, this OM, my lord, which governs the, my lord, marking pattern is at page 58 of the WPC 5584.
Yes. 58.
58.
But how do you take upon yourself this,
Exactly.
the how to give marks and who should give marks, how much should be given?
No, this is specified. You cannot give more than that. You cannot give less, you cannot give more. But everything is there.
Bring it.
You'll get your opportunity to rebut all this. At least
Lot of time
don't,
unnecessarily, that's why.
it is not unnecessary, it is necessary for the petitioner. So the court is hearing it is, if you were so busy, you can go to the other court. It is up to you.
Mr. Saikia,
Lordship.
yes, go to the point.
Yes, my lord, page 58, man.
What is the breakup which you are agreed with? Just tell me at page 57.
My
There-
lord,
there are-
presently,
There are certain breakups, isn't it? Experience,
Yes,
articles,
yes,
award.
yes, yes.
Which one?
I'm agreed, my lord, this leadership skill, administrative ability. At present, these two. Earlier, I had this
No.
also.
From the chart,
Yes,
from the chart at page 57,
yes, madam.
which column covers that point?
My lord, the result of school, if your lordship see, my lord,
Yes, 84.88.
after the marks offered by SSB, etc., my lord, the result of school,
Hmm.
84.88. So far as I am concerned, that is 1883.01.
Yes.
So now your lordship may come to my lord, this memorandum.
Yes.
Now this leadership skill is judged by the, my lord, result of HSLC, AHM examination in case of graduate teacher and HS final examination in case postgraduate teacher in the school where he is a teacher. So here, my lord, we are in a, my lord, HS final examination because it is a higher secondary school. Result of preceding year of selection. My lord, this selection was held in 2019. So preceding year would be 2018. So now his result, lordship will find page 60.
Hmm.
This 2018,
Hmm.
his past student percentage is 76.28,
But he has been given 84.88.
84.84.
So that is the thing.
That is the thing. And why they have given, they have taken the marks of 2019.
Advertisement for the which post, which year?
My lord, it was precisely on 35/2019.
13/5/2019.
19.
After the financial year.
In the school selection committee, they have taken to the, my lord, 18 only.
Why?
In the school selection board, they had
Uh-huh.
taken, now state selection board has taken up 2019. Because 2019, the interview was, advertised, last date was 7/6/2019. Interview held on 15/6/2019. So they have taken the marks of 2018. Now state selection board has taken up 2019.
Final exam happens in which time of part of the year?
My lord,
Final examination. Final examination is scheduled
Lordship, my lord.
in the beginning part of the year, mid-year or end of the year?
Media.
It's in the middle.
Middle. So when the advertisement is of 35/2019, last
Res-
date 7/6/19.
Last result is of 2018 only. 2019 exam hasn't held at that time.
Okay,
So 2018 only. So that
so it should be 2018.
2018. So there he gets, my lord, 76.28.
This is one point. Any other point?
Yes, ma'am. Now, second point, your lordship will find in the notification, my lord, your lordship will see, my lord, the person who gets between 60 to 79%, he is to get only 2 marks,
Where's that?
page 58. Page 58 against the leadership skill. Those who gets percentage of the school is between 60 to 79, he gets 2 marks. If it is 80 to 89%, in this case, it is 3 marks. And above 90, it is 4 marks.
Hmm.
So far as
So that it should have been what, 2 marks?
he should be getting 2 marks.
2 marks.
2 marks. So far as I am concerned, your lordship will find page 61.
61.
Two 2018, my 100% result. So I should be getting 4 marks.
And you are given 3 marks.
Mine given 3 marks because they have taken me to of 2019, 83.1.
Okay.
That is one.
Hmm.
Then secondly, you also will come to the page 58 once again, my lord.
Hmm.
Administrative ability. 2, my lord.
Yes.
Now here the marks for receiving the award by the school. Award, 2 marks, state award marks, national award or state and national award, 2 marks. We are not concerned there. B, award honors begotten by the school is student, teachers in academic, sports, social culture, even organized in state or national level by an organized government or private. He has participated in the academic seminars. There we are not concerned. Now, articles contributed by him in magazine and journal, newspaper, periodical on academic matters, 1 marks.
Hmm.
Now, in the result, this result sheet you will find in column after the award, word award article,
1 mark.
he has been given 1 mark.
You also 1 mark.
I am also 1 mark. Now, academics, my lord, has been published. Your lordship will find. You want also page 2? Page 65. This, my lord, article was published only in September 2019 when the interview was already over. Last date of, my lord, this submission of application was 7/6/2019 and this is September 2019. So he is not entitled to 2019.
So 1 mark should not have been given to him.
It should not have been given.
Okay.
And this is just an arithmetic, my lord. There is no, my lord, that the selection committee can give of their own, my lord. This is fixed marks. Right? So if these 2 marks is reduced from the leadership quality and 1 marks from there, so obviously, my lord, he'll be coming somewhere, my lord, 15 and I'll be retaining the 17. I'll be selected. Now, so far as the ground, my lord, what he has taken with regard to the, my lord, res judicata, my lord. My lord, CPC.
Let them reply.
My lord, senior counsel is saying, my lord, I should be replying to the res judicata only after
So
his.
basically your case is on the marks.
On marks, right from the beginning.
Right from the beginning, you say that marks has never been taken into account, although you have raised the plea.
Gotcha.
And they have gone to a direction of whether the college
B.Ed.
from where he obtained B.Ed was registered or not, or NCT recognized or not. Ultimately, it said that it is recognized, so he should be given.
Right.
But the question regarding marks still remains open,
It's okay.
and for which these writ petitions are filed.
Fine.
And you have shown me that marks are to be given in such a manner because of this marks.
Gotcha.
So That means you'll have advantage of 3 marks more.
He'll marks from 17, it will be reduced to 15. I'll be, my lord, retain the 17. So he'll be lesser marks. He's, I'm
15 or 17, 14 or 15?
15 because he's given 3.
3.
He should be getting 2.
So reduction should be how many marks?
2 marks.
2 marks in
2
all.
marks. 1 for article,
So
He-
the ultimate score will be 15 and 17.
15 and 17.
You will be 17.
I'll be 17. That is the ground.
And regarding whether you are affected by constructive res judicata or not, if
Lordship.
the point is taken, you will reply.
Yes.
Okay.
Yeah,
Mr.
if I
Chaudhary, we'll take 5 minutes break and come back.
Sure.
Otherwise, in the midst of your argument, we'll have to rise.
No,
It's better to rise now.
Surely.
I'll come back.
একটু সাবডিভিশনকে দিলেন না Yeah, তাদের তো নাম তো ইনো হ্যাজ বিন লিজিং অন দিদিয়া স্লিপ টু দিদিয়া Yeah, seriously, no? Yes. May it please your lordship. My lord, if your lordship would kindly come to page number 29 of WPC, I'll refer to only 4843. This is the first in point of time a writ petition was filed,
Page 29.
yes, by Majid Ali, that is the petitioner, my lord. He said that the selection process should be completed by having due regard to his representation dated 22/8/19. Am I clear, my lord?
Hmm.
So the order was passed saying you dispose of this representation. So far, so good. We have no problem with this.
Hmm.
Now, my lord, thereafter, he files the second writ petition. I'll come to my writ petition. 2442 of 23. Now he files WPC number 2442 of 23, wherein he challenged the order by which I was made the principal, and he also challenged the award of impugned award of marks. Am I-
Where's that? Where's that?
My lord, that is not there. I'm just handing over the copy, my lord.
Order copy.
No, the writ petition copy.
Order is here, otherwise?
No, I don't think it's 242. Oh, asa diyo, sunga. Asa. Now, please come to page 15, my lord.
Hmm.
In the
Yes.
premises aforesaid, it is most respectfully prayed that your lordships may be pleased to admit this, etc., etc. First, he prays a writ in the nature of certiorari to set aside and quash that 29/4/23, by which the petitioner was, the respondent number 6 was appointed as principal. Second prayer, Miller.
Yes.
A writ in the nature of certiorari and appropriate direction shall not be issued towards setting aside and quashing impugned statement of marks 15/6/19.
Mm.
Am I clear, Miller?
Yes.
So he made twofold prayer that my appointment should be interfered with, and two, that impugned statement of marks should be done away with, should be interfered with. Now, Miller will kindly have the CPC for a moment. CPC can do. Please come to section 11, Miller.
Good.
Res judicata, please come to explanation 4 and 5. For 4, for the present, I will not trouble your lordships. I'll have explanation 5.
Yes.
Any relief claimed in the plane which is not expressly granted by the degree shall, for the purposes of this section, be deemed to have been refused. if you make any prayer, if the prayer is not granted, then it will be presumed that it was refused. Now let us see, my lord, what was the order passed in 2442. Now lordship may kindly take the writ petition 4843. Page 45. Now, after referring to everything, my lord, page 50. I have considered the order dated 9th of March. I have considered the order dated 9th of March 23. A perusal of the same would indicate that a hearing before coming to a conclusion with regard to status of B.Ed degree of the present petitioner, now respondent number 6, what was directed by order dated 11/8/21 was that the concerned authority shall for the records, a call for the records from Borpeta BT College as well as from NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before the NCT. The order further directed that it was only when concerned authorities to issue an order in favor of the petitioner therein, respondent number 6 in the present writ petition, that a hearing would be held with regard to writ petitioner and the present respondent. That has not been done. Accordingly, matter is. So, my lord, this honorable court did not consider his prayer regarding statement of marks. It is possible, I was not present, he didn't advance any argument, because when he thought that by hitting one point, I'm getting a relief, why should I go to the other? That is where, my lord, he got a suicide goal. Because by virtue of explanation 5 of section 11, that relief was refused, meaning thereby it was not considered. So therefore, he cannot raise this point again in subsequent petitions.
In other words, he has missed the bus.
Yes.
Okay.
That means when he has missed the bus, now you cannot raise that point. Now, my lord, regarding my NCT part, now everything is clear. The government wrote to the NCT clarified that yes, the application was made before the stipulated date, therefore his degree is valid. Therefore, I have been appointed. Now, today, my lord, there is no appointment in his favor, but he is managing the show for the last 2.5 years. There is no appointment order in his favor. My order is stayed does not mean my order has been wiped out. But which is that order which permits you to continue as principal? Now, therefore, my lord, the matter is very simple. So this being the position, my lord, my learned friend's client cannot hesitate the point regarding statement of marks again and again and again. You have done it. You never pursued the matter. Court did not pass any order in your favor in terms of explanation 5 to section 11. That relief was denied to you. Once it was denied, it was denied. Now you cannot come to the writ court again saying, give me this relief. Now, my lord, regarding, my lord, there is one compilation. My lord will kindly come to page number 8, because in that order dated 29/4/23, lordship has found reference of an order passed in contempt proceeding. Please come to page 8 of this compilation. It was passed in the contempt case, my lord. List this matter on 12/12/22, enabling Mr. I. Alam, learned Standing Council NCTE, to apprise the court as to whether Regional Director, Eastern Regional Committee NCT has replied to the queries made by the state government in the Secondary Education Department through letters dated 14/6/22 and 28/9/22, as well as through emails sent to NCTE in the email address given so and so. Then on the next date, my lord, in the same contempt proceeding at page 10, it has been submitted that the state authorities have verified the credentials from NCT about which NCT has cleared. Accordingly, there should not be necessary appointment order. So, my lord, NCT has given clearance. Then please come to page 12 in the same contempt case. U. Sharma, learned counsel for the respondent, has produced a copy of the communication under memo dated 9/3/23, by which it is mentioned that NCT has indicated the documents relating to B.Ed degree of the petitioner, and therefore the secretary to the government school education department had decided that name of the petitioner be notified as principal of Bamundongra Higher Secondary School, Nagaon. Accordingly, it appears that order of the court is complied with. Hence, this petition stands closed. So, my lord, since there was an undertaking given, therefore this petition was closed. So, my lord, as far as I was denied appointment on the ground that the college from which I obtained my B.Ed degree was not recognized by NCT, which has turned out to be wrong. And it was he who propagated that idea, my lord. Nobody else. Therefore, my lord, that I possess NCT, a B.Ed degree from an institute which is duly recognized by NCT, that issue stands resolved, my lord. So therefore, there is no other hurdle. Now the question is, now the petitioner is trying to say that this is not my grievance. My grievance is a statement of marks. As I have already submitted, my lord, you have missed the bus. Now I'll rely on two judgments of the Supreme Court. Now please come to this compilation at page 13, my lord. It's a Supreme Court judgment. Please come to page 21. This is on the point of res judicata, principles analogous to res judicata. Page 21, para 10. The citation is, my lord, 1989, 3 SCC 151. 1989, 3 SCC 151. Before we consider the submission made on behalf of the tenants, would like to point we are unsuccessful before this court in Punjab. Teen have again filed petition challenging the validity of the Section 3 and impugn notification on additional grounds. In our opinion, the petition by such tenants are not maintainable, as the same are barred by principles of res judicata. Once petitioner challenged the validity of the impugned notification dated so and so in earlier proceeding, they ought to have raised all the grounds which could have been raised in impugning the validity of Section 3 and notification. If they fail to raise a ground in an earlier petition, they cannot raise that ground now in the present proceedings. Finality in litigation and public policy both require that litigants should not be permitted to challenge validity of provisions of the act on notification at different time on different grounds. Once petitioner challenged to Section 3 and impugned notification was considered by the court and validity of same was upheld, it must be presumed that all grounds which could validly be raised were raised and considered by the court. The learned counsel for the petitioners urged that questions which are being raised in the present proceedings were neither raised nor considered by the court. Therefore, it is open to them to question the validity. This was the submission. This submission is contrary to the principles of res judicata, as it further ignores the binding effect of a decision of the court, etc., etc., etc. Now, my lord, there are two aspects in this case. There could be a situation where a prayer is made, but the relief is denied. There, by virtue of explanation 5 to section 11, it would still be a constructive res judicata. The other situation is, my lord, you file different petition at different point of time on different grounds. Then it would be hit by general principles of res judicata. Now, coming to the facts of the present case, my lord, his prayer for re-verification of the statement of marks made in WPC 2442 of 23, having not been allowed, so my lord, it will be presumed that it was refused. So that way, the matter ends there. Now, in view of the general principles of res judicata, the subsequent to writ petition, that is 4843 and 5584 are not maintainable. And regarding my qualification, my lord, that is there. So therefore, both the writ petition needs to be dismissed. And my lord, he is enjoying a stay order for the last 2.5 years. So therefore, to sum up my arguments, my lord, is a very simple matter, my lord, in my humble submission, subject to what your lordships may say. The petitioner's initial grievance was that my B.Ed degree is doubtful. initially. Of course, he also raised the issue of statement of marks, which he never pursued. As he did not pursue, therefore he has waived. Now he cannot go on improving his case day by day. Otherwise, my lord, there will be no end to litigations. And principles of res judicata or constructive res judicata, these are all principles evolved in public policy. So here is a clear-cut case, my lord. His prayers are barred. Therefore, my humble submission is, my lord, lordships will vacate the interim order and allow the dismiss the writ petitions, my lord. Well, one more judgment it will be also. It's a very recent judgment, my lord, on res judicata. My lord will kindly come to paragraph 33. This sentence starting with almost 2 centuries ago. Para 33.
Yes.
Almost 2 centuries ago in Henderson versus Henderson, so-and-so was held. In trying this question, I believe I stated the rule of court correctly when I say that where a given matter becomes subject matter of litigation in and of adjudication by a court of a competent jurisdiction, court requires parties to that litigation to bring forward their whole case and will not permit the same parties to open same subject matter of litigation in respect of the matter which might have been brought forward as a part of the subject in contest, but which was not brought forward only because they have from negligence, inadvertence, or even accident omitted part of their cause. The plea of res judicata applies except in special cases, not only to points upon which the court was actually required by parties to form an opinion and pronounce a judgment, but to every point which properly belonged to the subject of litigation, which parties exercising reasonable diligence might have forwarded at the time. The principle popularly known as doctrine of constructive res judicata based on might and ought theory has been recognized by this court in several judgments, then refers to this Maharashtra Varikar case, my lord. Then eventually at para 35, the doctrine itself is based on public policy flowing from the age or legal maxim of interes republica ut sit finis litium, which means that in the interest of the state, there should be an end to litigation and no party ought to be vexed twice in a litigation for one and the same cause. So, my lord, these are all well settled principles, my lord. Therefore, to sum up my arguments, my lord, though at one point of time he pursued both the point, but because in 2442, the relief was not given to him. My lord, when does a court doesn't give a relief to a party? Let us visualize a situation. I may take 10 points. Supposing, my lord, 1 point is good enough to give me relief. For a moment, we forget, my lord, sometimes it is very dangerous. For example, in this case, today he will have to face the consequence. He should have pressed that point that no, my second prayer also should be considered. But on that day, he was satisfied with the first prayer. So now he is facing the consequence. The reason is, my lord, you can't blame the court because it is the party who pleads. He must bring to the notice of the court all the points. If you don't bring it, it is to your peril. That's why it is said, my lord, it is a policy, a principle in public policy. Because you cannot go on hesitating the same point at different point on different grounds. That is what order to rule 2 CPC also says. If you have got several cause of action, you must put entire of the cause of actions in the same suit. Today you cannot file a suit for principal and tomorrow you file another money suit seeking interest. It will be barred by order to rule 2 CPC. That's simple. Therefore, my humble submission is, my lord, both these writ petitions deserves to be dismissed because these are not maintainable. And on the point of NCT, he is not even pressing because my learned friend has made a categorical averment that regarding the recognition of B.Ed degree, I am not even concerned. If you are not concerned, then well and good. He has said that, he has made that submission. So only point is there, therefore survives in this case is the point which you abandon in 2442. Can you today hesitate in for this subsequent to writ petition? The answer is no. That is my humble submission. Deeply okay.
My lord, section 11, my lord, if your lordship. Section 11, my lord, it speaks, my lord, certain things, my lord. May I read, my lord?
Yes.
No court shall try and suit or issue in which a matter directly and substantially in issue has been directly or substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such has been subsequently raised and has been and finally decided by such court. So there has to be a final adjudication on the issue that has been raised. My submission is that there is no, my lord, final decision of this court with regard to the marks. My lord.
Yes.
Now, so far as he is trying to say, my lord, the relief I had claimed in WPC number 2442, not only for setting aside, but also the statement of marks.
Yes, go ahead.
Statement of marks, which was prepared by the school selection committee.
Hmm.
Because at any point of time during all these litigations, until this WPC number 4843 has been filed, it was nowhere, my lord, nobody has disclosed that the state has also, my lord, the state selection board has also prepared a list. They have filed their affidavit, but nowhere it has been said. Only on production of the record, it reveals, as I have already pointed out to the order dated 11/9/2023. Now, in WPC number, he's trying to say that my second prayer has been refused. But your lordship, once again, if you looks into the order, my lord, page 32 of WPC, lordship is holding 4843, my lord.
Hmm.
Page 45, my lord.
Yes. Which para?
Page 51.
Yes.
While hearing the petitioner and the respondent number 6, the rival claim of both the parties shall be considered. The marks obtained by, marks granted by the school selection committee, I have, my lord, already, my lord, at the beginning, I said these are illegally granted. So therefore, I have filed an application before the authority. They did not, having done anything. I have come to this court. Court directed them to finalize the process, taking into my grievance.
Mr. Saikia,
Lordship.
pursuant to this judgment or this order of 19/6/23, which you just read,
Lordship.
what is the follow-up that you have done or the parties have done?
Yes, my lord, thereafter the, my lord, this page 52, notice was issued to us.
Then where is your claim
My claim is page 53.
on this point, marks?
Yes, on the points, my lord, marks. So this is entirely on marks. From paragraph 5 onwards, Lordship may come, my lord. That an office memorandum of height so and so dated 26/12/18 regarding revised guideline for selection of principal of provincial higher secondary school awarding marks was issued by the commissioner and secretary to the Government of Assam Secondary Education Department. Wherein it stated that proper selection of principal in higher secondary school purely on the basis of qualities such as leadership skill, administrative ability, integrity, and commanding personality, academic career, etc., as stipulated under Rule 13 of the Assam Secondary Education Service Rule 23. The school selection committee as constituted under Rule 8(4) shall award total 30 marks to the candidate for the post of principal of HS school. That though on the basis of interview, the school selection committee prepared a panel list of on 15/6/2019 of 3 candidates where Sajal Kumar Das was placed at serial number 1 with 20 marks out of total 30 marks, and I was placed at serial number 2 with 18 marks out of total 30 marks. But the school selection committee has done great illegality by allotting higher marks to the Sajal Kumar Das, and he was not eligible to get highest mark. The Sajal Kumar Das was appointed as principal in charge of Bamundogra Higher Secondary School, Barpeta of Height, order dated 12/6/2019, and took charge of principal in charge of the said school on 13/6/2019. And the interview for the post of principal was held on 15/6/2019, and therefore he is not entitled for 1 marks in experience as in charge.
All
of
right,
principal.
Mr. Saiki, you don't have to read the entire thing.
Lordship, then this leadership quality, then administrative ability, everything.
That you have already submitted.
Lordship, everything. But the order doesn't
So-
reflect anything, my lord,
Uh,
at page 62. So for second prayer is concerned, my lord, this court did consider in the WPC 2424 and said, since my application is already there, so both the parties will be given a hearing, as this was also directed by the earlier order. Page 37, the earlier order. Relevant portion, my lord, again, my lord, paragraph 15.
mhm. Which para? Page?
Para 41, para 15. This was part of the earlier on, my lord. Order dated 11/8/2021. In order to be passed by the approving authority in the government is in favor of the petitioner for the purpose of other consequential action that would be required to be taken, both the writ petitioner and the respondent number 6 would be given an opportunity to hearing to put across these respective cases. This has been recited in the judgment passed in WPC number 2424, my lord. If your lordship, my lord, goes to the entire, my lord, judgment, if I am permitted to, my lord, read out, my lord, entire judgment, my lord. All these things, the past, everything has been taken, my lord, has been noted down, my lord, in the judgment, my lord, at page 46. That is the judgment dated 19/6/2023. Starts from page 45, plus you may come to page 46. All the sequence of events, my lord, right from the beginning, my lord, WPC number 4889. Page 46. Page 47, para 2, pursuant to an advertisement dated 35/2019, which was published in Dainik Assam for the
Mr.
post of
Saiki, I think I've understood.
lordship.
It is
So-
there. So same thing. Yeah.
So,
No
so,
need to read.
so there is no, my lord, conclusive decision of this court. This court said your application, and there is already a direction from this court that both the parties will be heard only after, if, my lord, the issue of, my lord, B.Ed certificate is resolved, or the authority decides to, my lord, pass the order in his favor. In that case, for the consequential relief, all will be heard.
Okay, you are on marks.
I am on marks.
What about the B.Ed? As on today,
As on today, even I'm saying I'm not on that, my lord.
you're not on that.
I'm not on that. It is purely on marks, because from the beginning, I am only claiming for marks. I'm not on the, my lord, B.Ed, as he said, but I'm not on B.Ed. That is the authority they have decided. So far as the marks is concerned. Now, so far as the, my lord, constructive res judicata, as I have, my lord, already said, my lord, referred to section, my lord, 11.
Hmm.
That the, my lord, issue has to be, my lord, substantially and directly is in issue in the subsequent proceeding. The issue in the subsequent proceeding should be directly or substantially in the former suit. And that has been decided in the former suit. Finality has been attained. Now here there is no finality. this court has never had an occasion to see, my lord, who has received how much marks as per the memorandum, my lord, this office notification. It was given to the authority. You decide, because he is already raising the case. This is a primary duty on the authority. They have to decide. They have to act on that. Once they decide, then of course this court will definitely, my lord, adjudicate. But they have not decided. So therefore, my prayer continues not only in 2424, but also with a subsequent, my lord, this 4843. But during the course of the hearing, they have come up with a plea. From the record, it reveals that particular statement of marks prepared by the school selection committee does not exist. Now, state selection committee has prepared a marks granting 1717 marks. This is another fresh cause of action which was never substantially or directly was an issue in anywhere, my lord. Not only the issue raised was a issue, though I have prayed, it was never an issue.
The first writ petition was 2442.
Yes. Yes, 244.
The
First.
first writ petition was
2790.
7980/2019
Oh, that was by the,
by
by
me.
you. Okay.
For finalization of the selection process, taking into account my objection I have raised. The court has granted
What
that
was your objection?
because of grant of the marks to him,
Okay,
contrary to the memorandum.
now. So in that 2019, you have already raised marks.
Marks raised, but this was never decided, my lord. Then they have passed an order in my favor appointing me as a principal.
No, but you were saying that which is directly and substantially an issue.
Lordship.
So was it not directly and substantially an issue in 2019,
It was.
which you continue to raise subsequently?
Till then, my lord, the finalization process was not there. I have raised a, my lord, objection before them.
Mm.
They were not, my lord, disposing of my representation nor decided the, my lord, selection process. So I have approached for a direction to dispose of my representation and finalization of the process.
That chart, when did it come, that chart,
My lord,
that chart, that marks?
after the, my lord, selection has been made,
No, at which stage, in which writ petition it came into the picture?
my lord,
That marks.
that has come, my lord, 2424, my lord,
In 242,
2442,
2442.
2442,
Okay,
2442.
that was a breakup given.
Breakup.
But on what basis did you file the 2019 then?
I have said, my lord, that he is to get the, my lord, the order itself, my lord, would reflect. My lord, the authority has in fact acted upon my application. They have asked for some report, joint secretary.
19 is there? That-
Yes, yes, it is there.
The case record is here, 2019.
Yes, yes.
Just show me for once.
First, your lordship will look into, my lord, the order once again, my lord, that,
No, I want to see what exactly is your prayer.
lordship.
Letter dated 22/8/19.
Lordship.
What is that letter?
My lord, that is at page perhaps of that record, my lord,
Page 13.
perhaps page 15, my lord.
Complaint received from so and so. Where is your complaint? This is your writ petition.
That is my petition.
But where is your complaint?
Well, that was forwarded by that letter, my lord, 22/8/2000.
No, only forwarding letter is there, but your complaint, where is it?
Plain, my lord.
This letter says in enclosing a copy of the complaint.
Lordship.
So and please necessary steps, but the enclosure is not there.
Lordship. Well, if I'm permitted to.
It was ISA code.
It was ISA.
You understand what I'm saying?
Just,
That forwarding letter is there.
Lordship, the
You have a
complaint,
complaint
itself
which
is
was
not-
forwarded, forwarding letter is available,
Lordship,
but the complaint itself is not there.
It's not there.
So what was,
It also speaks of, my lord, that B.Ed degree part in that letter itself. That was the primary grievance.
Assembly.
next 3.
In fact, everything was started with that.
so Saike, what was the reason for filing the complaint?
Well, 4 marks, my lord. But I have, my
For
lord,
marks. You don't have a copy of the marks at that stage. So on what basis you're making the complaint?
no, I had the copy, my lord. So I think the writ petition must have, my lord, resides, of course, my lord, it is not with me, my lord. I'm sorry, my lord.
What is not with you?
The copy of the writ petition, my lord,
I'm giving it to you just now.
Lordship.
Look at this.
Because this has to be approved by the state selection board, then only, my lord, it become final.
No. That is there. There's no dispute about that. See, how did you start making the story that there's some problem? On what basis?
Yes, yes.
You are saying that I want to complain, please redo it.
Lordship.
Redo on what basis? There has to be some hint that there is some regularity in the marks. I should get more, he should get less, something like that.
Or else the authority acted mechanically, my lord,
Uh,
in the absence of.
how will they act on it otherwise? I'm asking you this because you had raised the issue regarding directly and substantially an issue which has not been finally decided.
Finally, yes.
This is what you're saying.
Finally,
So show me where in this first writ petition that this was not raised.
There is no averment in the writ petition. In that 7890.
You are having a look at the second copy. I think it's the same thing, isn't it? I have the first copy.
No, they are holding that copy.
Well,
Two learned councils,
Paragraph 6, my lord.
two learned senior councils are arguing.
Well,
At least they're not saying that I was not the counsel in that case.
well, I was-
Sometimes that submission comes, isn't it? I was not involved in that case. It was somebody else.
I should be at least aware of all the facts. my
You
lord.
should be aware,
I
that's
should
what.
be aware, should have been.
You cannot put the blame on others.
Lordship, my lordship.
So,
My lord, the paragraph 6, my lord, some indication is there, my lord.
6.
Paragraph 6, that it is respectfully stated herein that having the required qualification and experience essential for the post of principal Bamundogra Higher Secondary School, the petitioner has a legitimate expectation of being appointed by the respondent. However, notwithstanding the fact that petitioner has all the requisite qualification for the post of principal Bamundogra High School, the petitioner is surprised to learn that the respondent authorities are contemplating to select the respondent number 7 as the principal of the Bamundogra High School. As a selection board has made a proposal for the same. Having learned the same, the petitioner submitted an application under the provision of right to information before the respondent number 4 and sought for certain information, entirely a list of marks allotted to the candidate or interview held on 15/6/2019 for the post of principal Bamundogra High School and marks allotted to Sajal Kumar Das, subject teacher, respondent number 7, in respect of leadership and integrity personally, but the school authority has refrained from furnishing those information sought by the petitioner till the date of till date for the reason not known to them. That's
Mr.
it.
Saikia, I have read this already, but I'm letting you read for your satisfaction.
Lordship,
It is not there.
Not there.
You have sought for certain information. What does it mean?
Lordship.
At least you should have hinted that I've got more marks. He's got lesser marks, or he's not qualified, or something like that. Just to clear your mind that you said, give me information.
That's
Why should they give you that?
Since nothing transpired, the petitioner has made a representation before the respondent number 2 with a prayer for re-examination of the proposal of the selection committee for the post of principal Bamundagara High School. And upon receipt of the same, respondent number 3 addressed a letter to the respondent number 4 by bearing number dated 22/8/19, whereby direction was issued to for re-examination of the proposal for selection of the regular principal higher secondary school. Accordingly, respondent number 4 by dated so-and-so addressed to the respondent number 6 with an instruction to attend his office chamber at 12 p.m. discussing with regard to the examination of proposal of selection committee for the selection of regular principal. That is submitted that respondent authority, more particular respondent 5 and 6 is refusing to examination of the proposal for selection committee for the post of principal Bamundagara without any cogent reason, thereby denying the petitioner an opportunity of being appointed as such fashion is not violative of so-and-so. So I did not have the marks, but then there's
No, not the marks. You may not have the marks. How much you got, how much the respondent has got. You may not have. It's not possible.
Lot.
The RTI was there was not answered, not
Lot.
possible. But what I'm asking you is the kind of hint, at least the slight hint of certain allegation that there was something wrong. Arbitrariness, manipulation, or you got more marks, or that should have been there. It's not there. And your complaint itself is not available.
But the fact of giving a complaint, my lord, is admitted, my lord, it ought to have been in record also, my lord.
You have started some
Lordship.
complaint.
Lordship, my lord.
On what basis? This is what I want to know. That is not there.
Evidence.
My lord, evidence sought for certain information inter alia, the list of marks allotted to the interviewer for the post of principal and marks allotted to so-and-so and so-and-so. My lord, my grievance is there, my lord. Had I received, because I said this person should not be getting and the wrong allotment is there, my lord. So give me the marks so that I can ascertain. And accordingly, that inquiry process has been initiated. But thereafter, having not proceeded, I have approached this court. This court directed that you finalize the process taking into this particular letter dated 22/8/2019. So it was their duty to, my lord, whatever the complaint. If I don't have a complaint, my lord, the state is not saying that I did not have this kind of, my lord, grievance. State is not saying so much. Nowhere in the affidavit also they have said.
I think that's all you have to submit.
Yes.
No, my lord, before, my lord, the res judicata, as I have said, my lord, the issue.
What do you say about explanation 5? Section
Denied.
11,
Yes, denied.
section 11,
If no
explanation 5.
is.
You have raised so many grounds. If not
Lordship.
decided, seems to have been decided.
No, that relief has been given. It has been directed the authority to hear both the parties. Well, because they are the primary authority to hear my objection. It is not this court. My lord, if I, my lord, no doubt I have made a prayer, but till then it was perhaps the premature because my application was there. The authority was directed. My lord, what about that direction, my lord? These are not, my lord, redundant or, my lord, surplus in the order, my lord. This has a specific, my lord, that while hearing both the parties to be heard and decide the matter. And my objection, I have, my lord, given what are my basically objections. These are only on the marks. And I have also shown, my lord, that how the, my lord, the marks have been allotted. I have this, after this judgment of, my lord, in 2424, my specific, my lord, objection is there. That has not been touched in any of the orders subsequently.
All right, I've heard you.
Yes.
That's it. That's all I
Yes.
think.
Well, only one thing.
Well,
I
on
forgot
the-
to point out one factual aspect. And one small submission on substantive provision of section 11. My learned friend is bringing the analogy of my lord, the other facets are also constructive res judicata. Not only what is contained in substantive provision of section 11, that an issue substantially decided will be a res judicata subsequent suit. That is one. That is main facet. And these are the ancillary facet. 5 is an ancillary facet. If you make a prayer, your prayer is denied, then it will amount to refusal. That means that is gone. These are all public policy, my lord. This is a statute, legislative wisdom. My lord, there's one more aspect, my lord. If your lordships would kindly have the order dated judgment in 2442, I forgot to point out this, just 1 minute, my lord. When we challenge his appointment, my lord, what he said, that's very important. Please come to page 40 of WPC 4843.
Paragraph?
Paragraph 11 at page 40. When we challenge his appointment, what was his stand? Now, can he go on appropriating and reprobating?
In 2442.
Yes, my lord. Judgment, it starts at page number,
Where is the order?
it starts at page 37 of 4843.
It is order dated 19/6.
Yes. No, my lord, 11/8/21. No, sorry. Sorry, I'm very sorry, my lord. Order dated 5/8/58 of 21, sorry.
358.
Page 37, yes. When his appointment I challenged, my lord, when the matter was remanded, kindly see his contention. Now can he take all this plea now? Para 11.
Just a minute, huh? 5584.
Yes, my lord.
That
No,
page-
my lord. No, it's okay. 3558 of 2021. Page
Oh,
37.
3558. Yes,
Yes,
I got
yes.
the order.
Yes,
Paragraph number
11, my lord.
11. Okay. Yes.
Now, in this writ proceeding, my lord, my learned friend's client was respondent
Order number
number
6.
6. Yes, and he was represented by SN Sharma, learned SN Sharma, learned senior counsel for the respondent number 6. On the other hand, contends that the decision of the government while granting approval under 13(5) is a right decision, and respondent number 6, upon being appointed, had in the meantime assumed the charge as principal. So now then, when he was appointed, everything was fine. Now, when I am appointed, everything becomes wrong. So can you do this in law? So at that point of time, you say this selection is absolutely okay. Now, in a subsequent collateral proceeding, can you take a U-turn? So this is in law called approbation and reprobation, which cannot be. That's my humble submission.
This is his writ petition. no,
Yes, in my writ petition, where you,
His writ petition, I cannot say.
no, in
that,
his writ petition, I
Well,
challenge your
all the-
appointment.
All the principles of law has been molded the way it requests for him.
I have not
Yes.
said anything. I have
Yes,
said what
but-
Supreme Court has said for your
Yes,
information.
yes.
I have not
That's
said
been-
anything of my
that's
own.
been-
I have relied on
This
Supreme
is,
Court
this is,
decision.
this is not even based on his pleading as well. This is not
Okay.
based on his, but so far as the res judicata, what that has been read, I'll just.
And my lord,
two-
from
two
17/8/2021, he is in charge, my lord. There is no order
Rightly, my
against
lord,
him.
I have got more marks as you have, lordship has seen, my lord, 17 marks, my lord. Just because procedural law, my lord, that I'm yet to
No,
submit.
it's
my
not a question of.
Yes, my lord, this is what CPC is a procedural law, my lord, that I'll place on it, my lord.
Oh,
I'll come to that, my lord.
Now, apart from the petitioner and the private respondent, who are the other respondent?
The government.
State.
Yes.
What is your role?
In 4843, we have filed our affidavit. And in our affidavit, we are mainly concerned with the DSDT.
No. What is your role? Who's the select? What is the composition of the selection?
State.
State director.
does it.
Director.
Director gives the approval, my lord,
Director. is
after
the-
the selection committee.
And the selection committee comprises of
District level and state level.
district level, state level.
So it was through by all the committees. Only glitch was, my lord, regarding my B.Ed degree, whether my B.Ed degree is valid, because that's an essential criteria.
It's the marks, my lord. It's marks what I am happy on. Not the.
Okay. But I'll have to hear the department also.
Yes.
What they have to say.
Yes.
Deeply offended.
And yes, and department plus who else? Any other party?
No, my lord, department.
This will be higher.
Madam, may I conclude by submitting this to judgment on res judicata, my lord? My lord, I'll submit afterwards, my lord. I'll submit.
You can conclude that 2 to 3 minutes are there, then I'll hear you.
Lordship. I'll just give the judgment video.
Yes, which one first?
My lord, AR 1977, Supreme Court 1680.
Yes.
Paragraph 3. The principle of estoppel per res judicata is a rule of evidence as has stated in Marginson versus Blackburn Borough Council 1939 2 KB 426 at page 47. In my state, it may be said to be the broader rule of evidence which prohibits the recession of a cause of action. The doctrine is based on two theories: the finality and conclusiveness of judicial decision for the final termination of dispute in the general interest of community as a matter of public policy. The interest of the individual that he should be protected from multiplication of litigation. It therefore serves not only a public but also a private purpose for obstructing the reopening of matter which have once been adjudicated upon. It is thus not permissible to obtain a second judgment of the same civil relief on the same cause of action, or otherwise the spirit of contentiousness may give rise to conflicting judgment of equal authority, lead to multiplicity of the action, and bring the administration of justice into dispute. It is the cause of action which gives rise to an action. And that is why it is necessary for the courts to recognize that a cause of action which results in judgment must lose its identity and vitality and merger in the judgment with pronounced. It cannot therefore survive the judgment or give rise to another cause of action on the same fact. This is what known as the general principle of res judicata. But it may be the same set of facts may be raised to two or more cause of action if in such a cause of case a person is allowed to choose and sue upon one cause of action at one time and to reserve the other for subsequent litigation. That would aggravate the burden of litigation. Courts have therefore treated such a course of action as an abuse of process. So and so, my lord. Then, my lord, will come next page, my lord. This is therefore another and an equal necessary and efficacious aspect of this simple principle, for it helps in raising the bar of res judicata by suitably constructing the general principle of subduing a cantankerous litigation. That is why the other rule has some been referred to as constructive res judicata, which in reality is an aspect of amplification of the general principle. So that's the broad distinction between constructive and the constructive res judicata and the res judicata. The first of all, my lord, the issues has to be decided, it has to be finally decided, and the litigation should be terminated. Now here the litigation, so far as the issue is concerned, that has not been decided. Then secondly, in the second writ petition, I have raised the marks granted by the state selection committee, which was never a issue in either of the writ petition earlier. So question of constructive res judicata also does not come in. This one. This again, the others one, but then the latest one of my lord, AR online 2023 Supreme Court 237. Para 34, the general principle of res judicata under section 11 of CPC contains rules of conclusiveness of judgment. Para 34. Para 34.
Yes.
The general principle of res judicata under section 11 of CPC contains rules of conclusiveness of judgment, but for res judicata to apply, the matter directly and substantially in issue in the subsequent suit must be the same matter which was directly and substantially in issue in the former suit. Further, the suit should have been decided on merit and the decision should have attained finality.
Yes.
The third judgment, my lord, AI 2005 Supreme Court 3304.
Okay.
Relying on paragraph 11, my lord. All the rules of procedure. As well as-
Yes.
All the rules of procedure are the handmaid of justice. The language employed by the draftsman of procedural law may be liberal or stringent, but the fact remains that object of prescribing procedure is to advance the cause of justice. In an adversarial system, no party should ordinarily be denied the opportunity of participating in process of justice dispensation unless compelled by express and specific language of the statute. The provision of CPC or any other procedural enactment ought not to be construed in a manner which would leave the court helpless to meet extraordinary situation in the hands of justice. Then, my lord, paragraph 13. The processual law so dominates in certain system as to overpower substantive right and substantial justice. The humanist rule that procedure should be the handmaid, not the mistress, or legal justice compels consideration of vesting a residuary power in judges to act ex officio justice, where the tragic sequel of otherwise would be wholly inequitable. Justice is the goal of jurisprudence, processual as such substantive. Then 15 minutes. 14, let's say, may escape the same thing, madam. 15, processual law is not to be tyrant, but a servant, not an obstruction, but an aid to justice. Procedural prescription are the handmaid and not the mistress, a lubricant, not a restraint in the administration of justice. Now, this I am submitting, even if for any reason, though I have said there is no constructive res judicata, no res judicata, even then Lordship has seen the marks awarded, which is an statutory prescription, that it has to be awarded by the notification dated so and so. And it is apparent, there is no argument advanced that the marks awarded are right. So therefore, he comes 15, I came 17. Now, because of this procedural for any aspect, whether the person can be would be denied, madam. So that is left to the court.
So we'll come back at 2 and
Gotcha.
hear Mr. Sharma.
I've got the item number 23 for hearing. But today, I think there's little chance of reaching it. Item 23. Otherwise, I'm ready, but can it be on fixed either next Tuesday or Thursday? That day I'll upgrade because every day it comes as last item many times and never reach.
Hearing date. 18. 18 of November. 18 November. 18 November.
18 November
Tuesday.
is. Can it be little bit earlier, my lord? Because the person is going to retire his increment and everything because of medical leave, my lord. He's suffering. The case is relating to sanction of the medical leave and increment, etc.
See, like you
So-
said, it also depends on the number of cases already
Yes.
fixed. So no point having it as the last item
Yes.
again, isn't it?
This one, 18 November. Okay, my lord.
18.
Let it be. 18 November. Anyway, whenever 18 November, I have to mention it. Because my lord, every day is it never reached 6, 7 times. It did not reach, my lord.
All right. That's
Anyway.
by Ms. N. Saikia, learned counsel for the petitioner. Released the matter on 18th of November 2021 for hearing.
Oblige, my lord.
In petition 4843, we have filed our affidavit here, madam.
4843, this is the early one.
Yes, earlier.
Let us see that. What have you stated? 4843 is before me. Yes.
Page 75, madam. And they filed filed this writ petition challenging the impugned order dated 18/8/2023, issued by the respondent number 1, whereby decision was taken to notify Sri Sajal Kamal Das, respondent number 6, as principal, Bamundugra Higher Secondary School, and to set aside and quash the impugned statements of mark dated 15/6/2019, prepared by the School Selection Committee, Bamundugra Higher Secondary School, Borpeta. And kindly come to the page 80, paragraph 7. The deponent begs to state, being aggrieved, the petitioner filed by the writ petition by WPC number so and so before the Honorable Court, and accordingly on 8/5/2023, the Honorable Court passed the interim order as under. Until further order of the court, the parties to this proceeding shall maintain the status quo as on today with regard to the post of principal of Bamundugra SS School, District Borpeta. Accordingly, in compliance of the aforesaid interim order dated 8/5/2023, the Office of Director of Secondary Education, Assam, issued an order file number so and so dated 16/5/2023. Moreover, while disposing WPC number 2442/2023, file order dated 19/6/2023, the Honorable Court directed accordingly, the matter is remanded back to the Secretary, School Education Department, to rehear the petitioner as well as the respondent number 6 on the order that is to be passed by the concerned authority, and thereafter pass appropriate orders in accordance with law within a period of 2 months from the date of receipt of a copy of this order of this court. Consequently, the order dated 9/March/2023 issued by the Secretary to the Government of Assam Department of School Education is set aside and quashed. While hearing the petitioner and respondent number 6, the rival claims of both the parties shall be considered. The status quo order passed by this court earlier shall continue till a final decision is made by the concerned authority. The concerned authority shall thereafter forward communicate the order passed to the petitioner as well as to the respondent number 6. Subsequently, the Secretary to the Government Department of School Education conducted a hearing of the parties on 11/8/2023 in compliance of the Honorable Court order dated 19/6/2023, passed in so and so, and subsequently an order has been issued by memo number so and so dated 18/8/2023, where it is observed that after verification all relating record documents to the B.Ed degree of the petitioner and careful consideration of above and approval of the competent authority obtained accordingly, it is decided that Sri Sajal Kamal Das may be notified as principal, Bamundugra Higher Secondary School, Borpeta. However, due to interim order of Honorable Court dated 23/2023 passed in so and so, the consequential order has not been passed. So as per our affidavit, it is notified that the Sajal Kumar Das as a principal. Yeah.
Go on, Mr. Yu Sharma.
Madam. Yes. This was the stand of our affidavit in 4843. 4843, and subsequently they have filed this writ petition 5584 of like 2023. And here record was produced. And thereafter, my lord, come today for order again here. And the respondent number 6 challenge this, my lord, regarding the a question raised regarding the res judicata matter.
Yes.
So in this revision, we have not filed our affidavit here. In that,
Seven, the other writ petition you have not filed,
yes, my lord.
5584.
Yes.
Why? Any reason for that?
No, actually, we have not received our instruction till now, my lord. As because, my lord, in the midterm, it was heard by the honorable court and take it as a CFA for judgment by it. Subsequently, it is come to order right now.
You come to page 81, which you just read.
One of
81 of the writ petition.
4843.
4843, yes,
Yes, my lord.
which you just read now, your affidavit in opposition.
Yes.
Second paragraph from the top.
While hearing the petitioner and the respondent number 6, the rival claims of the parties shall be considered.
So what have you
The-
considered?
Yes.
What
It
what
is the
have you
direct,
considered? What have you considered?
my lord, here, my lord, as per
Then
the order, my
say-
lord,
No,
it was the order, my lord, 19.
please come to the same page, last paragraph.
Yes,
Subsequently,
yes.
read.
Subsequently, the secretary to the government Department of School Education conducted a hearing of the parties on 11/8/2023 in compliance of Honorable Court Order dated 19/6/2023 passed in WPC number 2442/2023, and subsequently an order has been issued by memo number so and so dated 18/8/2023, where it is observed that after verification of all relating record documents to the B.Ed degree of the petitioner and careful consideration of the above and approval of competent authority obtained accordingly, it is decided and that Sri Sodal Komal Das may be notified as principal.
So you are speaking only of the B.Ed degree.
Yes,
What about the marks?
my lord, kindly come to the page 50
Hmm?
of the writ petition, page 50.
Yes.
Serial number 7, my lord.
No, that we have seen.
Yes,
You come to page 51, second paragraph,
51, yes.
same thing which you read just now. Then come to the page 53. Submission of written objection.
Yes,
Paragraph 1. Regarding marks,
yes.
paragraph number 6. Regarding marks. What did you do? Hearing conducted on 11/8/2023.
Yes.
Is there any material in the affidavit that this was the proceeding. Hmm?
In the order itself, it was stated, my lord. Order dated 18/8/2023, page 62, my lord.
What is stated?
Here findings, the petitioner WBG so Sajal Kamal Das was appointed as subject teacher mathematics.
No, don't read the entire thing.
Yes.
You just point
Being
out
aggrieved,
anything written about marks. Not written. You'll not find it. Don't search.
regarding that, regarding marks.
You have not said anything, you'll not find it.
Yes.
Now, what do you say about res judicata?
My lord, regarding res judicata, earlier writ petitions, my lord, all are disposed of, my lord, and right now I have no such petitions also in my hand. So,
Anything more? That's it?
my lord,
Mr. Sharma?
regarding the res judicata, my lord, it is difficult to make any statement for me, my lord, because earlier all those writ petitions are already disposed of, and my lord, in this order also, it is not reflected regarding his marks also, that he claiming the marks here for correction. So, my lord, regarding that, I cannot say anything, my lord.
Anything else, Mr. Chaudhary?
Yes, sir. My lord, regarding the principle of res judicata, my learned friend has placed one judgment.
Oh.
Now, my lord, my humble submission is very simple. If we go by the substantive provision of section 11 CPC, what it mandates is between the two parties, there cannot be two proceedings. That is the substantive principle of res judicata. What I am arguing is constructive res judicata. The explanations which are there, otherwise, my lord, what meaning we give to 5? My lord, there is no dispute that pursuant to the first order in 7890 of 2019, it was revisited. Am I clear to your lordships, my lord? It was revisited. If your lordship would kindly take the 4843 for a moment. 4843. Please come to me, Lord, page number 28. Page 28. Kindly mark the date on the right hand side top, 15/6/2019. Has your lordship got it? This was before the order passed in that 7890.
Page 28.
Page 28 of WPC 4843.
This is a statement?
Yes, my lord, that's the statement of mark.
No, where's the date?
On top, my lord, right hand side, date of interview, 15/6.
Oh, date of interview.
Yes.
Okay.
Yes.
Mhm.
Kindly see, my lord, the petitioner, respondent number 6, who was given first nomination, he secured 20 marks. On the right hand side, my lord. Then the writ petitioner Majid Ali, he got 18.
Mhm.
Second, my lord,
Yes.
18. Then my lord will kindly come to page 27. Itu do. No, itu ko. Itu para buat tu. So this was on 15/6. Subsequently, my lord, pursuant to that order, it would go. Huh? Five, five. Now, if your lordship would kindly take the WPC other one, my lord. 5584 for a moment. Huh? Page 57. একটু তারিখ কি মনে ছিল? Page 57.
What is the difference between these two?
Now it is reduced to 17, my lord.
Why is it like that?
My lord, they revisited pursuant to the direction of the court.
Very,
Pursuant to the order passed in 7890, the entire exercise was revisited and this is the result. And my learned friend is submitting that that has not been acted upon. My lord, my fundamental argument stands. It is barred by principles of constructive res judicata stands, but on even on merit, this is the factual position.
all right.
Yes. Now, one averment from my affidavit, my lord, where we have stated this position. If your lordship would kindly take para 13 of the affidavit filed in 4843, para 13. Paragraph 13 at page 7 of the affidavit filed by respondent number 6 in 4843.
Yes.
That thereafter the writ petitioner again approached this honorable court by challenging the aforesaid order dated 29/4/23 by filing writ petition number so and so on the ground that though the direction contained in WPC number 358 was to hear the writ petitioner before a decision is taken, but the same was not being done and order dated is liable to be set aside. This honorable court by order dated dispose of the writ petition direction to rehear the writ petition and the deponent. In compliance of the said order, parties were called for hearing on so and so, and both were heard on the said date. Accordingly, pursuant to the hearing taken place on so and so, secretary to so and so passed the order, whereby decision was taken to notify the present so and so as principal so and so. It is very pertinent. Apparent from the order that writ petitioner has given sufficient opportunity to raise his grievance, and every time by filing petition before this court, the present petitioner has deprived the deponent from his legitimate right. So, my lord, pursuant to the order, it was revisited. And after the following revisit, my lord, it was made 1717. And my lord, as a PG, that is the instruction I received, my lord. I'll just give one information, my lord. Sorry, actually, my lord, the writ petitioner, my lord, he obtained B.Ed. He obtained B.Ed in 2018. And I got B.Ed in 1997.
Is there any?
That's why, my lord.
Is there any time frame fixed that you should be before?
No, if you have got lesser, then as a PG, your experience will be less. So B.Ed is only 1 year. So he had PG with B.Ed only for 1 year. Whereas I got marks for 22 years, he got only for 1 year. PG and post-graduation and B.Ed, he obtained B.Ed he obtained in 2018, whereas I obtained in 97. I think government affidavits should disclose all this position. So this is the position, my lord. Therefore, it's not correct that it was not revisited. And my lord, my learned friend is referring to judgment. I am placing your lordship the first constitution bench judgment on applicability of res judicata, my lord. My lord, the Air 1961 Supreme Court 1457. Well, I'll hand over a copy, my lord. I'm just reading. This is a constitution bench judgment, my lord. Iman?
Mr. Chaudhary, you hand over the judgment. I'll go through it.
Yes, my lord, paragraph 8 to 13.
8 to 13. You have a printout?
I'll give a print.
All right, so we'll close the matter.
Yes, deeply obliged, my lord.
Please write, heard Mr. PJ Saikya, Arnett Senior Counsel. For the petitioner, now assisted by Mr. M. Kolita. For the petitioner in both the writ petitions and Mr. K. N. Chaudhary, Arnett Senior Counsel, assisted by Mr. S. Hazarika for the respondent number 6 in both the writ petitions, and Mr. U. Sharma, learned standing counsel, secondary education, appearing for the said department in both the cases. Stop. Both the writ petitions are being disposed of by this common order. In the present case, is with regard to the filling up of the post of principal Babun Dongra High Secondary School. In terms of the advertisement published in the daily newspaper within inverted comma, Dainik Assam, close inverted comma, dated 30/5/2019. So the last date for filling up of the submission of the application was 7/6/2019. And both the writ petitioner as well as the private respondent number 6 applied for the said post. Stop. Interview was held for the post in question on 15/6/2019. And a panel list was prepared whereby the respondent number 6 was placed in the first position. Stop. The petitioner, not happy with the outcome of the interview process and the allotment of marks, submitted a complaint before the respondent authority concerned. Stop. Since the same was not acted upon, the petitioner filed WPC number 7980 of 2019. with the following prayer, colon dash, small Roman 1 bracket, writ in the nature of mandamus, directing the respondent authorities, more particularly the respondent number 5 and 6, to re-examine the proposal of selection committee for selection of principal of the school in view of the letter dated 22/8/2019 issued by the respondent number 3, bracket, Joint Director, Secondary Education, Assam, close bracket, semicolon, within bracket, small Roman 2, call for the records and on hearing the parties to make the rule absolute and or to pass any such order or further orders as deemed fit and proper by the court. Next para. Although counter affidavit was not filed by the respondents, including the present respondent number 6, who was arrayed as respondent number 7, this court, provide order dated 6/12/2019, disposed of the writ petition by directing the respondent authorities to do the needful and complete the process of selection for appointment to the post in question as per rules, and also by taking into consideration the letter dated 22/8/2019. By which the Joint Director of Secondary Education had written to the Inspector of Schools, BDC, Borpeta, enclosing a copy of the complaint submitted by the petitioner with certain allegations. The next para, person thereto, the Director of Secondary Education, Assam, issued an order dated 29/7/2021 by which the present writ petitioner was appointed as principal on regular basis
May I interrupt one moment? Madam? May I interrupt?
Yes.
In between, there is a communication at page 32 of WPC number 4843. Page 32.
Yes. What is this?
This is joint secretary after the first order, my lord, in WPC number 7890. This communication was again made.
No, is it required to be referred to? Because I'm going straight to the outcome.
I just pointed out. Because there specifically marks and all these anomalies are soft format by this communication.
Stop. It was further provided that the order would supersede any earlier order issued by the office for placing the in charge principal of the said school. Next para. Aggrieved. The respondent number 6 filed WPC number 3558 of 2021. Challenging the order of appointment issued in favor of the present writ petitioner. So of this court, upon going through the various provisions of the Assam Secondary Education bracket provincialized close bracket service rules, 2003 bracket rules of 2003 close bracket disposed of the writ petition by judgment dated 11/8/2021. By remanding the matter back to the government to verify from the records as to whether Barpeta BT College, from where the present respondent number 6 had secured B.Ed degree, had made its application for recognition to the National Council for Teachers Education bracket NCTE prior to 18/8/1997 or subsequent to the judgment of this court rendered in WPC number 3289/2020, open bracket, Pranita Sharma versus the State of Assam and 7 others. Close bracket. White judgment dated 25/2/2021. Stop. It was further directed that the appropriate authority shall specifically call for the records from the Barpeta BT College as well as from the NCT to arrive at a factual satisfaction as to on which date the college had made application for recognition before the NCT. Stop thereafter. Appropriate order may be passed. So both the writ petitioner in the present case, you cut that. Both the writ petitioner and the respondent number 6 in the present case were to be given opportunity of hearing to put across their respective cases. So pending such decision, the present writ petitioner was allowed to continue as the principal of the school. Next para. After the writ petition was disposed of in the above manner, the Director of Secondary Education passed an order dated 29/4/2023 appointing the present respondent number 6 as the principal of the school, and the writ petitioner reverted back to his original post. As graduate teacher, bracket, advanced Assamese, close bracket, of Rehabari Higher Secondary School, Barpeta, with immediate effect. To stop, the order indicated that such an action was taken after careful consideration and upon obtaining the approval of the competent authority. Stop, the present writ petitioner being aggrieved filed his second writ petition, namely WPC number 2442 of 2023. Briefly highlighting the nature of his grievance of being replaced by the respondent number 6. Who according to him was given marks which it's a lady, isn't it? Number 6.
No.
Lady,
No.
both male, which he did not deserve. So of this court, upon considering the projected case of the parties, was of the view that the earlier direction passed in judgment dated 11/8/2021 in WPC number 3558 of 2021 having not been complied with in the manner it was directed, found it appropriate to remand the matter back to the Secretary, School Education Department for rehearing the petitioner as well as the respondent number 6 of the present writ petition. White order dated 19/6/2023. From white you cancel. Just put full stop. Accordingly, the writ petition was disposed of. White order dated 19/6/2023. Stop. This court had also set aside the order dated 9/3/2023 by which the state government in the School Education Department had given it the approval for appointment of the respondent number 6 as principal of the school. So it was further provided that while hearing the rival parties, their respective claims should also be considered. To stop, the status quo order passed earlier was directed to continue till a decision was arrived at. And that the authority should immediately communicate the order to be passed to the rival parties. Next para, following the above direction. The rival parties were, the rival parties as well as the Director of Secondary Education and Inspector of Schools, Borpeta, were informed by the Additional Secretary to the Government of Assam School Education Department about the schedule for hearing, that is 11/8/2023. And the parties were asked to appear along with all relevant documents, papers, etc. on the date fixed. To stop, the petitioner on 11/8/2023 submitted his written objection to the Secretary to the Government of Assam School Education Department. Okay, after this, what was the order passed?
18/8/23.
Hmm,
18/8/2023.
18/8.
18/8.
Okay,
Page 62 of WPC 4843.
I got it. Now, as scheduled, our hearing was accordingly conducted on 11/8/2023. And the Secretary to the Government of Assam School Education Department consequently issued an order dated 18/8/2023 by which the earlier order was modified and the respondent number 6 was found to be fit and eligible to be appointed as the principal of the school concerned. This is the last order, isn't it? After this, there's no order. This is, it says, may be modified as principle also. Where?
Page 65. Please, Sadam Kumar, in the last, may be notified. Concrete is practical mistake in the relevant.
May be notified means what?
Because my lord, there was a interim order, also it is notified and the case is not.
Show me the order. Where's the order? If it's notified.
That's page 65, my lord.
Oh, 65,
Yes.
the typed copy is also there from page 62.
Yes.
Same thing. It just says that
The last line, my lord.
Mr. Sharma,
63 is like, same. I copy of 60. This one 65, that number that is like copy 60.
oh, see the language, it is decided that Sri so and so may be modified as principal of the school, may be modified. So that means one more step is required to issue the notification. Is it available? No. I think this is the last one.
Order dated 27/8/2023 has 23/8/2023 has been passed, directing them not to pass any order,
Interim order.
interim order,
Huh?
not to pass any final, because. it was
That's an
not final.
interim order, but
Lodged.
there is no such kind of
No.
notification, isn't it?
Lodged.
No, my lord, if perhaps the final order could not be notified because of the interim order.
Correct, I understood. Interim order came immediately, so that's
Yes,
why.
yes, that's right.
On 23/8/22.
So after this, you file this 4843.
For report.
Next para, I agree, the petitioner.
My lord, I think one fact Lordship has not incorporated to be required. If your Lordship kindly have a look at para 12 of the writ petition 4843 of 23.
Hmm.
Because that is his specific case that it was not revisited. Para 12 আছিল না? Of-
14 of WPC 5583.
Oh, sorry, 5584, my lord.
Paragraph?
Paragraph 12. Because his case was while arguing that it was never revisited. Page 14, para 12. Sixth line, thereafter, this honorable court directed respondent to produce the records of the selection committee regarding marks allotment to the respondent number 6 as well as petitioner. Thereafter, on 11/9/23, records were produced before this honorable, and thereafter petitioner got to know that in the year 2020, that is on 26/11/20, State Selection Board, the respondent for had reviewed the panel prepared by respondent school selection committee and prepared an impugned statement of marks awarding whereby both petitioner and 6 were awarded 17 marks. So his contention that this was never revisited is not correct. His statement, in writ petition.
So it was revisited,
Yes,
17 marks.
that is his statement.
Yes, yes, well, that is impugned, that statement of marks are impugned in the WPC number 5584. Because it revealed only while record was produced before the court.
No,
That-
if it's revisited, then what remains?
My lord,
If it's revisited, what remains in your submission?
my lord, whether it
Your
is re-
submission is that they've, regarding B.Ed and all that, I have no objection.
No objection,
But regarding the marks given to him,
lodged,
this is not correct.
not correct,
So it should have been,
corrected,
but now you say that it's revisited.
revisited when
Then-
it was produced before the court. I have impugned that, saying that this revisitation is also not good.
Only.
Because I have showed my lord 17/17, he is not entitled to my lord leadership by 1 marks and the,
Alright.
so therefore that is also not correct.
So your submission also has to be slightly modified then.
Yes.
Yes, so this has been modified.
Not a case, not a total case that it was never revisited.
Ah.
It was revisited, but
was
marks
never-
was not given properly.
No, it was never communicated first of all, and when it was communicated on perusal, it found that that is also not correct.
Hmm.
So I have challenged that it is subsequent writ petition.
No, 2016 is not checked.
See, anyway, I'm coming gradually to that. Mr. Chaudhary has pointed out for you,
Lordship, my lord.
I was still on 4843.
Lordship.
Then we'll jump to 5584 very soon.
Yes, yes.
What was the last sentence? The petitioner filed. This will be the third, isn't it?
In fact, one more.
No,
thing,
sorry, this is second for you or third for you.
This,
4843,
This is his petition.
that will be heard.
third.
Side of.
How many have you filed?
First, second,
Man-
third,
no.
fourth, it will be fourth,
There are 4 writ petitions.
fourth, total fifth, five.
5, 1 by me, 4 by him.
Oh, this is your. the
This is
third.
fourth, my third
Third. Fourth is 5584.
by me.
Agree if the petitioner filed his third writ petition. That is WPC number 4843 of 2023. With the following prayer. A to A. Page 22, 23, and 24. So of this code, while issuing notice of motion. No, cancel that. This code, wide order dated 23/8/2023. Directed that till the next date fixed, the respondent authorities should not pass any final order. Pursuant to the order dated 18/8/2023, issued by the Secretary to the Government of Assam, School Education Department. To stop the interim order continues till date. What prompted you to file the thing? Is the
Hello.
marks.
Order dated 11/9/2023 in WPC number. In the WPC number, this 4843.
Order dated Mr. Saikia,
11/9/23.
what do you want to point out?
The record was produced and this code having on perusal found that the state selection board is there, that decision. I was given an opportunity to go through it.
Then
So, Malad, that for the first time, Malad, this has deemed to have been communicated to me. So I have challenged this statement of marks in the subsequent writ petition.
the records was produced and it was found that you got 17 marks. Private respondent also got 17 marks. So you wanted to challenge that?
Yes, that has been challenged in the WPC 5584. Because that was never communicated earlier. And even in the affidavit Lordship has submitted by the state government in April 2023, they are relying on the statement of marks prepared by the school selection committee, not even the state, my lord. But since record is containing this, so I have challenged that also. Whether they have, my lord, acted upon it or not, but the affidavit doesn't say that they are relying on that state selection board.
Who produced the marks?
The record was produced, my lord, by the
Department.
department. From the record, it revealed. On perusal of the records, Honorable Court found that the statement of marks prepared by the state selection committee is exist.
That's all.
Then what is this affidavit? This is the part of the record filed by way of affidavit. Page 83. No, this is the previous one. Please write down on 11/9/2023, when the matter was listed, the Lornette Standing Council for the Secondary Education Department produced the relevant records, which reveal that both the writ petitioner as well as the respondent number 6 have been awarded 17 marks each.
By the state selection board. Earlier it was school selection board, now state selection.
So you mean to say two different boards considered?
Yes, no, that's the procedure, my lord. Eventually, it is the state selection board who will make the final selection.
No, the first list was prepared by whom?
By the
By
school.
the school,
By the school.
then it is sent.
They
to-
are, they
Then it's
are,
sent to the state.
Yes,
that's sent to.
Then
the-
they again add subtract marks again.
They did that, man.
they verified, my lord.
They verified, they corrected it.
Because
according to them.
initially I was given 20, he was given 18.
What did I say? By the state
Selection board.
selection board. In contrast to 20 marks given to the private respondent number 5 and 18 marks given to the writ petitioner
By the.
by
state
the
School selection. board.
school selection board. Stop. The writ petitioner having discovered,
Number 6, my lord, not 5.
6.
sorry, respondent number 6, huh? The writ petitioner having discovered the marks allotted to him as well as the respondent number 6. And having found the same to be contrary to the, what is that thing?
OM dated 26/12/2018.
To the revised guidelines
Gotcha.
for selection of principal of provincialized higher secondary school for awarding marks circulated White Office Memorandum dated 26/12/2018. Filed his fourth writ petition. That is WPC number 5584 of 2023. with the following prayer, A to A, huh? Page 24, 25, and 26. Next para, appearing for the writ petitioner, Mr. P.J. Saikia, learned senior counsel, submits that the respondent number 6, in violation of the office memorandum dated 26/12/2018, was awarded extra marks illegally and thereby
under leadership skill and administrative ability.
bringing his marks at par with the petitioner. To stop referring to the office memorandum, the learned senior counsel submits that maximum 4 marks can be allotted towards leadership skills, subject to the conditions stipulated therein. To stop, he submits that although the result of the school in the examination, in the final examination for the year 2018 was 76.28%, the respondent authorities have taken the percentage of 84.88 pertaining to the academic year of 2019. Which resulted in granting of how many marks? 1 mark,
3 marks.
3 marks.
Otherwise, he would have been entitled to 2 marks.
Resulted in granting 3 marks to the respondent number 6 instead of 2 marks. To stop further, towards administrative ability, and in respect of contribution of article in magazines and journals, etc., on academic matters, 1 mark was given to the respondent number 6, although the journal was published only in the month of September 2019. Any other mistake?
Not, so far as my leadership method, I would have been getting 4 marks because my percentage was 100. but they have taken off 2019, so they have given me 3 marks.
Whereas in case of the writ petitioner, he was entitled to be given
4 marks.
4 marks under the heading leadership skills of the office memorandum, since the pass percentage of the school for the year 2018
Is
was 100%. Stop. However, the respondent authorities instead have taken the pass percentage of the year 2019, which is not correct. In view of the fact that the last date for submission of the application in terms of the advertisement was 7/6/2019.
And the marks of preceding year will be taken into consideration.
And therefore, the marks of the preceding academic year, that is 2018, is to be taken into account. Full stop. He therefore submits that since such consideration has been illegally and arbitrarily done to the detriment of the writ petitioner, the respondent authorities should be directed to make necessary rectification and appoint the petitioner formally as the principal of the school concerned. Full stop. He also submits that the principles of res judicata would not be attracted in the present case in view of the fact that the issue directly and substantially involved has not been finally decided by, has not been finally decided. Which can be seen from the order dated, impugn order dated. Where is that?
18/8/2022,
Hmm.
page 60.
Hmm?
Page 62, 88.
62, isn't it? Order dated 18/8/2023. I think that is more or less your submission. And then the judgment. Isn't it?
Lordship.
The learned senior counsel, in support of his submission, has relied upon the following authorities: : number 1. Three. State of UP versus Nawab Hussain. AIR 1977 SC 1680. Number 2. Srimati Rani Kusum versus Srimati Kanchan Devi and others. AIR 2005 SC 3304. And number 3. Prem Kishore and others versus Brahm Prakash and others. AIR online 2023 SC 237. Next para. Mr. K.N. Chaudhary, learned senior counsel, appearing for respondent number 6. While addressing the court in WPC number 4843 of 2023, submits that it was the prayer of the petitioner in WPC number 7980 of 2019 for considering his representation oblique complaint submitted for re-examination of the proposal of the selection committee, which was forwarded by the Joint Director of Secondary Education Department, via his letter dated 22/8/2019 to the Inspector of Schools, Borpeta District Circle, to take necessary steps for examination of the claim of the petitioner. Stop accordingly, this court, via order dated 6/12/2019, disposed of the writ petition by directing the respondent authorities to do the needful and to complete the process of selection for appointment to the post of principal of the school concerned within the time frame. The Alliance Senior Counsel has also drawn the attention of this court to the subsequent writ petition filed by the petitioner, that is WPC number 2442 of 2023. More particularly, the prayer portion,
Layer number 2.
wherein the petitioner had prayed for setting aside and quashing the statement of marks dated 15/6/2019, prepared by the school selection committee on account of respondent number 6 having been illegally awarded extra marks and placed in the first position. Full stop. In this connection, the learned senior counsel submits that section 11, submits that explanation Roman 5 of section 11 of the Code of Civil Procedure 1908 bracket CPC is attracted. Full stop. He submits that the provision clearly provides that any relief claimed by the claimed in the plaint, which has not been expressly granted by the decree, shall for the purpose of the section be deemed to have been refused. Stop. He submits that applying the principles provided therein.
My lord, I am not invoking res judicata, which my learned friend said. I am invoking constructive res judicata.
It is clearly demonstrated that the principles of constructive res judicata is attracted, and the petitioner cannot re-agitate the same grievance over and over again.
Because by the order, only relief on the other front was given. This was expressly not given.
Where is that order?
Yes, madam, that's 2442. Page number 30 की मंथ से 36 584 हां 5284 नहीं 82 जो है 44 page number 45 madam
of
4843 paragraph 7 page 50. This confined to only that B.Ed part, nothing else.
He submits that in fact this court has considered the prayer of the petitioner and have decided the matter White order dated 19/6/2023 in WPC number 2442 of 2023 by remanding the matter back for rehearing.
No
To the-
order was passed expressly on the other aspect.
Respondent authorities concerned. Stop. He submits that no order in respect of the second prayer made by the petitioner was passed of the petitioner in WPC number 2442 of 2023 was passed. And the petitioner himself did not raise any grievance. To stop, therefore, it is only clear that the principles of constructive res judicata would be applicable and the writ petitions should be dismissed on this ground alone.
On merit, my lord, mark was revisited. On 26/10.
The learned senior counsel further submits that even on merit, the marks given by the school selection committee had been revisited by the state selection committee. And the marks secured by the rival parties
Page 57.
57 of 5584. my lord. 26/11, 2019, 2020, 20.
arrived at 17 marks each. Now, what would happen if 17 marks each? One has to be
Because of age, my lord.
age. Okay. To stop, he therefore submits that even on merit, the petitioner cannot have any legitimate grievance to make. Stop, he therefore submits that both the writ petitions should be dismissed and the respondent number 6 be formally appointed as the principal of the school concerned. In support of his submission, the learned senior counsel relies upon the following authorities.
The one in that compilation,
uh,
that is, my lord, 1989 3 SCC 151, para 10.
measures M oblique S, okay? M oblique S, Kesho, Ram and company and others, etc. versus Union of India and others. 1989, 3 SCC 151.
Yes.
And the other one is
Otherwise,
it Samir Kumar?
Ah.
Number 2, Samir Kumar Majumdar versus Union of India and others. 2023 SCC online SC 1182.
para 32, 33 and 34. And finally, my lord, 1961, AIR 1961 SC 1457.
And number 3,
AIR 1961 SC,
yes, I got it. Just give me the paragraph number.
yes, paragraph 19, my lord. Here, what had happened, my lord?
90, 90.
19.
19.
Here, what had happened? A 226 petition was dismissed, then a 32 was sought to be filed in Supreme Court. As a country. Amongst others, it was held that principles of res judicata and constructive res judicata is applicable to writ proceedings. Therefore, he cannot maintain. Yes, if it is a dismissal in limine, in that case, not. Otherwise, if it is decided on merit, as further proceeding is not maintainable. Para 19.
Dariao and others versus State of UP and others. 1961 SCC online. No, you write this. You cancelled 1961. You write AIR 1961 SC 1457. Next para, Mr. U Sharma, Learned Standing Counsel, Secondary Education Department. By referring to the affidavit of opposition. Filed by the respondent number 2. In WPC number 4843 of 2023. Submits that the respondent authorities, in fact, in compliance with the court's direction dated 11/8/2021, passed in WPC number 3558 of 2021. And also the order dated 5/2/2023, passed in contempt case bracket C number 23 of 2022. Filed by the respondent number 6, passed the order dated 9/3/2023, which was after careful consideration of all the relevant materials and due approval from the competent authority. Concluded that the respondent number 6 should be notified as the principal of the school concerned. Stop. Since the steps taken by the respondent authorities are strictly in accordance with the direction passed by this court, the petitioner cannot have any grievance. Stop. He also submits that a formal appointment order could not be issued in view of the interim order passed by this court. Sharma, anything else? Any of the parties would like to add anything?
No.
Okay. So separate order. Heard Mr. So-and-so, so-and-so, okay. Hearing concluded, judgment reserved.
Deep present. Okay.
Yes.
Graded at numbers 20 and 51. For hearing.
So this is regarding my not including, you said IA was there, so that's
IS,
why.
but IS, the IA number 2117 of 2025 in petition number 7626.
IA for?
IA for implementation file.
We should have been listed in the order.
Orders column, my lord.
2117.
2117. my lord. Well, the opposite parties to be implemented as respondent number 4 to 18.
Okay, who are they?
My lord, here challenge is to a gradation list, my lord.
No, whom do you want to implead?
My lord, this
You will find it from page number. The names.
names, page number
to
start,
five.
page number, inside internal page number 3.
Page number 3,
Yes,
starting from
starting from Munindra Kumar Das, my lord.
Munindra Kumar Das.
Yes.
And who else?
There are many, my lord.
1, 2, 3, 4, 5, 6. Total 15.
Total 15 are there.
Oh, total 15. They will be
Respondents.
numbered as 4 to 18.
Yes.
4 to 18. Any objection? No objection. So we'll dispose it of then.
Yes, ma'am.
Heard Mr.
D. Chakravarti.
D. Chakrabarti, learned counsel for the applicants or what? Or
Applicant one.
Applicant. Stroke writ petitioner,
Yes.
who submits that by filing this application, the applicant seeks implement of the persons arrayed as respondent numbers 1 to 15 in the application as respondent numbers 4 to 18
4 to 18.
in the connected writ petitions. Since any order to be passed by the court while deciding the writ petition is likely to adverse their right and interest.
Yes.
To stop, he submits that it would only be for the ends of justice if they are impleaded, so that they may also be heard. Mr. S. Bora, learned standing counsel.
SCERT. SCERT.
S, what is that?
The State Council for Education Research
And trade.
SCERD.
RT.
Lots
S-
find in page number 2.
Oh, SCRT.
SC.
Okay, SCRT. Submits that he has no objection if the application is allowed. Anyone else? That's it.
Second writ petition.
Connected one.
Okay,
Now
okay.
this is only for the this one.
Yes. Considering the submissions made by the parties and upon perusal of the application, the prayer for impleadment of the parties concerned is hereby allowed. IA stands disposed of. Then in the writ petition, which writ petition? 7626.
7626.
In WPC 7626, you write, in view of the order passed today in ISE number 2117 of 2025. Allowing implement of new respondent numbers.
4 to 18.
Allowing implement of new respondents who are to be arrayed as respondent numbers 4 to 18, comma, the petitioner shall file an amended cost title in 2 sets before the registry of this court within 3 days, whereafter the registry shall do the needful.
So we have to take steps also. Man.
Should I issue notice at this stage?
No, my lord, after this, after amending, we have to take steps on the newly implemented respondents.
How? There has to be an order.
Yes,
Or should I pass the order now?
yes.
That's what I'm saying. Then the amended cost title be also supplied to Mr. S. Bora, learned standing counsel, SCRT. Next para, issue notice to the newly implemented respondent numbers 4 to 18, returnable by 4 weeks. Stop. Petitioner to take steps for service of notice upon them by registered post with ADU within 1 week. List again after 4 weeks.
Oblige.
4 weeks, what to do?
Can it be before 4 weeks? It's not inconvenient.
What, is this emergency?
That's it. Anyways to be taken down.
I'll just say list off again after 4 weeks on a date to be fixed by the registry.
Oblige.
petition item 3.
My lord, this matter has been returned back from CAB, my lord. And the date, fix a date for the hearing, my lord.
Yes.
13/11. Can it be on 13/11, my lord? My consent has been taken from my senior, my lord. Other,
All are appearing. You are for the petitioner.
I am for the petitioner, my lord.
Mr. Chaudhary is
For
for
the
the
private respondent.
private respondent.
As per
And
number 6.
private, and department, who is there?
Government advocate is there.
Pertaining to which department?
Education department. Higher education.
Higher education. Anyone from higher?
কিতাপখন ঘূৰাই দিয়া মোৰ কাৰণে আনিছে
Written argument already submitted there.
Actually, these are all matters which.
Okay,
Okay, my lord.
we'll see. As agreed to by the parties, let the matter be listed on 13th of November. For hearing.
Well, there is an interim order, my lord.
Anyway, that will continue, while in any case it is.
For admission hearing. Interim order passed earlier shall continue to the next day.
I am deeply obliged.
4 and 5.
আমার তো নতুন নেক্সট
This will require some time, my lord, because this is the third round of litigation. Your lordship had dealt with the first round of litigation. Your lordship's order was, then it spilled over to the second round, division bench upheld your lordship's order, and then this is the third round. And this will need some time.
If it's upheld, then how come third round?
No, my lord, it was a fresh cause of action because they again issued another transfer certificate. And we had to come before your lordship, and your lordship had stayed that.
All right, when do you want?
So we fix it for hearing. It can come for hearing.
This is for admission.
Admission, my lord. It can come up for hearing.
Will issue rule then?
My lord.
Parties are represented by the respective councils. Issue rule returnable by, issue rule. Issue rule, stop. Since parties are represented, no fresh notice is required. We'll stop. As prayed for, let the matter be listed for hearing. After,
The month of November, my lord, anything.
My lord, 20th November, my lord, 20. If it is not inconvenient, my lord.
is there a regular hearing list?
Regular in the fifth year, my lord. Yes, my lord.
There is.
Monthly, there is one hearing list that comes.
20th November. Apart from that, we have the daily, I mean, Tuesdays and Wednesday,
Thursdays.
hearing list. When can we have it? What?
20th November, my lord. Or my lord can have it on 27th November.
Gayan?
Yes, my lord, 20th November, my lord. 20.
27, hearing date.
20, my lord, 20th.
On 20, or list on 20. November 2025 for hearing.
Yes.
No, interim protection passed earlier, may continue.
Interim order passed earlier shall continue till the next date of listing.
Oblige.
Must.
Item 6.
May it please, your lord.
Yes.
My lord, this matter is relating to the family pension, my lord. The husband of the petitioner was working as lecturer at DR College, Gulagat.
You are there.
My lord, I'm for respondent 4, my lord.
Some instruction was
My
required.
lord, I have sent letter to the authority, my lord, college authority, my lord. It was sent on my lord 28/8, my lord. It is August 20, the instruction was not provided, my lord, till date, my lord. Since the matter relates to my lord, all pending matters, my lord. That's why college authority did not trace out the record, my lord.
What was the instruction required? Okay.
Other persons, my lord, who are getting pension, my lord. Similar to the petitioner, my lord.
17/7/25. So we'll give one more date,
And the last chance, Lordship.
one more date, and if there's no information, then we'll proceed
My lord.
as part of the. Although some time was granted to the respondent number 4 to instruct Mr. PJ Saikia, their appointed counsel. On the issue involved. But Mr. PJ Saikia today submits that he has still not yet received the instructions. Now, considering the urgency expressed by Miss
P. Borman.
MS P. Bora,
Borman.
P. Borman, learned counsel for the petitioner. Father, 2 weeks' time
My lord.
is granted as a last chance for securing the instructions.
Lordship, date may be fixed.
If no such instructions are forthcoming, court may consider proceeding with the matter on the basis of the materials available on record. You want a date? Okay, list on 25/11.
Must be.
How well?
Seven, 8, and 9.
May I please your lordship? Lordship, I'm appearing in item number 8. Lordship, may I pray to take up this matter in some other day, lordship, for final disposal?
I am for item number 9, madam. But
All of you riding in a common train. If one bogie goes, the other bogie will have problem.
But my lord, I am for item number 9, my lord, as per affidavit filed by the finance, my lord. Further affidavit is required from the education department as well as the finance, my lord. My lord, here, my lord, reminder is issued by the finance to the education department to file the fresh proposal, my lord.
Education department has not
Yes.
filed the affidavit.
Yes,
or-
that is why, my lord,
So education needs to file the affidavit, lordship.
finance as well as
Finance has
education,
already filed, lordship. That is
my lord. In item number 9, my lord.
education,
So who is there? Education? Which education?
secondary education.
Secondary.
And we are instruction is everything made of, so sometime may be granted.
3.
That we can file our affidavit manually.
How much time?
2 weeks maybe.
2 weeks' time. Okay, we'll grant some more time.
My lord.
Mr.
Only date may be fixed, my lord.
U. Sharma, learned standing counsel, appearing for the secondary education department, is granted further 2 weeks' time to obtain instructions and to file the affidavit in the possession of the said department. List again on so and so.
Lordship, I have one, Lordship, in item number 7, that is WPC 212 of 24. Lordship, finance's name has not been shown. So Lordship, there is a possibility that so Lordship, a copy of that may be served upon us, Lordship.
Which
Item number 7, Lordship. These are all 3 matters have been tagged together. So, Lordship, our names have not been shown in item
Yeah.
number 7, Lordship.
Give him a copy.
Yes, so that.
List again on 24. 25.
Next.
25/11. 11 or 10? 25/11/2025. Name of SC Finance
Yes.
be reflected against WPC number
2121.
2121 of 2024. Yes,
Obliged.
in the cost list, huh? In the cost list hereafter.
Obliged.
Lordship. Lordship, I have a prayer, Lordship. In item number 6, my lord, on 25/11, I will be not available, my lord.
Okay, which date you want?
Prior to 25, my lord, any date. 16, 17.
Huh? I had given you 25/11, is it? Give me a date then. Twenty. 20. Okay, make it 20.
That's okay. Item 10.
You are for the,
Here I am appearing for the petition. Mr. R. Bor Pujari appears, Lordship. I am appearing on his behalf. Lordship is just on his way. Lordship, here,
last time it was said by him that his file a reply affidavit.
yes, Lordship.
Office note says that there's no such affidavit.
Lordship, affidavit in reply, Lordship, we have filed on the 5th of August 2025, Lordship. I have the office copy, 5th of August.
But, just a minute. Then why do they reflect that there's no affidavit?
Have,
Oh, it's there. Okay, sorry, I had this, okay. It is there, sorry.
Lordship, yes.
I was looking at some other order.
Yes.
So what is to be done?
Lordship, here today, there's a interim order already operating, Lordship, and today it will take some time, Lordship. If Lordship wishes, Lordship may.
No, are you to appear or your friend?
Lordship, Mr. R. Bor Pujari appears. I was informed that he's on his way only, so Lordship. He's
On his way.
yes, Lordship.
And who will be his opposite side?
The opposite party will be education department. Well, Lordship may just pass over the matter for the timing he's on. Lordship may just.
Okay, let him come.
Lordship may pass any order in his presence, Lordship. I am just asking for timing. Timing, well, I hear, sir.
Well, you are ready?
Yes.
Sharma?
Yes. Already an interim order, Lordship, in our favor, so.
What is the interim order?
One post was asked to be left vacated, Lordship.
Head assistant.
Yes, sir. Lordship, Mr. Bor Pujari, sir.
May I please, sorry, my lord.
Oh, it's okay.
My lord, on the last occasion, my lord, the affidavit in reply filed by me was not tagged on record.
It's tagged now.
It is tagged now. My lord, the precise issue here is that, my lord, they have issued a transfer order. My lord, whereby I have been asked to report and get myself, my lord, posted in a different place. Now, one can understand, my lord, the transfer is an incidence of service. I cannot per se hesitate anything against the transfer order. But if the transfer order is being issued as a punitive measure, if the materials on record or the transfer order itself, my lord, ex facie, my lord, demonstrate that it is a punitive transfer, then, my lord, I have to be given a right of hearing. I have a right to be heard before passing the transfer order, because it is in the nature of a punishment. So therefore, if lordship.
Where is the order?
Yes, that order, lordship will find that.
Page 30.
Yes, my lord.
Speaking order.
Yes, my lord. I'm so obliged. Page 30.
How do you say this is a punitive order?
Because, my lord, whereas a complaint, my lord, may I read it, my lord? Whereas a complaint has been received from Inspector of Schools. So there is a complaint. BDC Borpeta District Circle, Borpeta, white letter dated so-and-so against Sri Hitesh Pathak, that is the petitioner, my lord, Senior Assistant of Office of Inspector of Schools, BTC Borpeta, making harassment to the junior office staff and taunting them. Whereas some employees of the Office of the Inspector of Schools, Borpeta, and some witness also put their signature on the complaint submitted by the Inspector of Schools, Borpeta, against Hitesh Pathak, that is the petitioner. Whereas 2 news items were published in Assamese Daily, Assamia Protidin, so-and-so, and Amar Assam, against Sri Hitesh Pathak, that is the petitioner. In view of the above, Sri Hitesh Pathak, so-and-so, is hereby transferred and posted in the office of the principal of so-and-so at his own grade and scale of pay, Vice Srimati so-and-so, Senior Assistant, retired. So I was, my lord, initially working in the office of the Inspector of School, Borpeta District Circle, Borpeta. Now I have been transferred in the same rank and in the same scale of pay, my lord. as a senior office, assistant of office, my lord, to the office of the principal of Government High School, Barpeta.
This is also in Barpeta only.
This is in Barpeta. There is no difficulty, my lord. I have
You're
honored
not
it.
going anywhere. You are in the same town.
I am in the same town, but my lord, fact remains, expressly this is a, my lord, order in the nature of a punishment,
What is the authority you have?
my lord.
What is the authority you have?
That, my lord, to the
Decision of the apex court in
Yes,
this
yes.
regard.
My lord, I will place it. My lordship will kindly accommodate me, my lord, because I was under an impression, my lord, that
Oh, I thought you were going to
my lord,
go for hearing.
my lord,
You produce one authority, you will consider.
absolutely, absolutely, my lord.
Mr. Sharma,
Yes, absolutely.
it seems you don't have a case.
No, it is a administrative order, man. It is an
I will
administrative
place.
order, so it is, madam.
No, see, some complaint is there.
Yes, complaint.
Some signature is taken and all that here and there,
Yes,
and then they transfer it.
It is not a
Is
matter
it not
of
punitive?
senior.
Is it not punitive in nature? Person cannot be taken like that without giving up a chance. Minimum adherence to the principles of natural justice
Yes.
is required.
Yes.
You
And-
hear him and transfer him, no problem. But without hearing him, why do you transfer like that? Can we just dispose it of, saying that give him an opportunity, let him be heard,
yes,
and then let them take a decision?
yes.
My lord,
Mr. Borpujari, till then you will not move. You
Yes.
have an interim order in your favor.
I have an interim order.
So,
but-
let it be disposed of.
dispose of, my lord, yes,
How long can you stay like that by way of stay order?
yes. Stay
Okay.
order, yes,
Yes.
my lord, stay order is, my lord, then if lordship may be pleased to interfere with this order, my lord,
We will interfere with,
yes.
and then they'll pass a fresh order after hearing you.
After hearing, yes.
Part Mr. R. Borpujari, learned counsel for the petitioner, and Mr. U. Sharma, learned standing counsel.
Secondary.
Secondary education, paying for the said department. What is this matter? Item number? Admission matter. Okay. Having regard to the nature of the grievance projected by the petitioner, the writ petition is taken up for disposal at this stage with the consent of the learned counsels for the rival parties. Next para. It is the case of the petitioner that a speaking order dated 5/7/2024 bracket annexure E
My lord,
has been passed transferring the petitioner from the office of the Inspector of Schools, BDC, Barpeta, to the office of the Principal of Government High Secondary School, Barpeta, in his own grade and scale of pay. And that the same is by way of, and the same is of punitive nature in view of the fact that certain allegations have been made against the petitioner, which has prompted the transfer order to be issued. Stop. Referring to the impugn order, Mr. R. Borpujari, learned counsel for the petitioner, submits that it is alleged that some complaint has been received from the Inspector of Schools, BDC, Barpeta, against the petitioner of harassing his junior officer and taunting them. Stop. In this regard, some employees of the office stood as witnesses and appended their signatures on the complaint. Stop. However, without giving any opportunity to the petitioner to represent or defend himself against such complaint, the impugn transfer order has been issued. To stop. Therefore, the same being in clear violation of the fundamental rights of the petitioner and in violation of the principles of natural justice, the same should be set aside. Stop. Mr. Sharma, what is any affidavit filed?
Yes, my
What
lord.
is your stand in one line?
My lord, they have only made a repetition of the contents of the speaking order. That much only, without any explanation. Lordship will find their affidavit from running page number 46, my lord.
Mr. U. Sharma, Lanet Standing Counsel, Secondary Education, by referring to the
48, my
affidavit
lord.
in opposition filed by the respondent number 2, submits that
Page 48, my lord. Whoever petitioner senior assistant of the office of the inspector of school BDC
the
Borpeta
petitioner
was transferred and
was
posted
posted as a senior assistant in the office of the Inspector of Schools, BDC Borpeta,
on 29/5/2024 on the morning in presence of every employee present at the office during the office hours. The petitioner senior assistant at the office of the inspector had broken the wooden bounded wall of RMSA engineer room, which was being temporarily attached to the upon desk to assist the stenographer to look after online pension Kitagota portal. Further allegation also made that the petitioner always used to harass and taunted to the junior office staff. And it was published also in the newspaper. And accordingly, speaking order was passed.
what is the last sentence? And in view of his conduct in the said office, as witnessed by all other employees of the office, the petitioner was transferred in his own grade of pay to the office of the principal of the Government High Secondary School, Borpeta. What was that word you had used by way of routine transfer? What did he say? No,
Broken off some.
no. You had submitted earlier that this is administrative action
Yes.
by way of an administrative order. Gustav, he submits that the same cannot be considered to be punitive in nature in view of the fact that sufficient opportunity was given to the petitioner to rectify his behavior and to maintain administrative decorum, which he failed to do so. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. What can be seen from the impugned speaking order is that a complaint had been received by the Inspector of Schools, BDC Borpeta, wide letter dated 29/5/2024 against the writ petitioner, making some certain allegation against him. To support the complaint, signatures have been obtained from witnesses who are also employees of the office. Stop. The respondents, apart from saying that sufficient opportunity was given to the petitioner to rectify his behavior, have not demonstrated anywhere in the counter affidavit that an opportunity was given to the petitioner by issuance of a show cause notice on the complaint or received by the Inspector of Schools, BDC Borpeta. To stop, opportunity granted to him to rectify his behavior can by no means take the place of issuance of a formal notice and giving opportunity to the person concerned to show cause as to why he should not be proceeded against departmentally. To stop, since it is clear from the record available before this court that there has been clear violation of the principles of natural justice, this court deems it appropriate to set aside the speaking order dated 5/7/2024. Stop. It is ordered accordingly. Next para, notwithstanding the interference with the speaking order dated 5/7/2024, the respondent authorities is so advised to proceed to take appropriate steps on the petitioner would be at liberty to do so. But the same should be resorted to by strictly following the principles of natural justice as well as the relevant disciplinary rules in this regard and not otherwise. To stop, it is also to be understood that the observation made herein should not be construed as a mandatory direction to proceed against the petitioner. To stop, it is entirely left upon the respondent authorities to take their own decision. With the above observation and direction, the writ petition stands disposed of. The interim order passed earlier stands merged with this order.
I'm so obliged, my lord.
Kevin Burrow.
Due to paucity of time, as per the last order.
Today also, my lord. Here, what happened, my lord?
Today also same order has to be passed.
Today, here, what happened, my lord? Admittedly, the petitioner is the senior most teacher of the school. And he has been found qualified for promotion to the post of principal. But at the first initial stage, he was denied, his promotion was denied because he has obtained his MA degree outside the state. The petitioner approved this court. This honorable court held that his MA degree is valid. Now, second time, my promotion was denied because of the fact that a disciplinary proceeding is pending. And disciplinary proceeding is taken up because of the fact that I have obtained my MA degree outside the state without permission of the authority. So I have challenged the DP, my lord. So at this stage, my lord, may I pray, my lord, a date may be fixed.
Date will be fixed, but the thing is that where is the counter affidavit? Who's appeared?
They have not filed, my lord. That's why
It is a matter of 2025 only, my lord. So
what
sometime
my promotion, I am at the verge of retirement, my lord. Although admittedly I am eligible.
to get obtain our instruction and file our affidavit, my lord.
What he's saying is that a matter of 2015 also, they are not filing counter affidavit.
Normal.
So how can we expect that
Your
matter of
lordship,
2025 counter affidavit?
Next time matter was listed sometime in June, my lady, sometime in August. And your lordship was pleased to pass on an order for listing matter after 2 weeks. It never listed, my lord.
Anyway, I think we should grant them some more time. This
Yes,
is the-
time may be granted, the
this
date
is
may
the
be
third
fixed.
time only.
One. The date may be fixed.
As paid for, Mr. Ayuddin, learned counsel appears for the petitioner. And Mr. U Sharma, learned SC, secondary, appears for the State Department. And prays for some more time to obtain instructions and to file counter affidavit. The prayer is allowed. List again after 3 weeks.
Yes, 3 weeks.
The date may be.
On a date to be fixed by the registrar.
But that will never come, my lord.
It will come.
Because your lordship,
Affidavit also should come. The date also will come.
unless a date fixed, my lord, it will never come. Even your lordship, the last week of my lord, November, no problem. A date may be fixed.
Okay, give a date. 27/11.
Oblige.
Please, your lordship.
Your time is not in his favor, my lord. Since
Every
we
time,
are-
is it?
My lord,
Yeah, why is it listed today?
For final hearing, your
For
lordship.
admission hearing,
Yeah.
isn't it? Can
Lordship,
it be taken up some other day?
my lord, on Friday next, my lord.
Friday next.
31.
lordship,
No, let it be not on a Friday. Let it be on a hearing date. Because Friday hearing date, I mean, normal motion date, there are a lot of matters.
Then my lord, November. November
4th of November,
my lord.
Tuesday, hearing date.
I have some difficulties, your lordship. My father expired, so I have some rituals to perform. I won't be
Oh,
able
I'm sorry
till
to hear that.
12.
You'll be able on?
Till 12, I won't be able to
Okay,
appear.
then when can you come?
On 18th,
12 or 13, your lordship.
13 Thursday.
13?
13 is Wednesday,
Thursday.
13 Thursday. Okay, we can have it on 13.
My lord.
As paid for by the parties, let the matter be listed on 13th of November 2025 for admission hearing.
Oblige, your lordship.
Yes, Mr. Sikdar,
My lord, time is
you've been
up.
waiting whole day
My
for
lord.
this matter. What?
Matter was earlier heard. It was in CAB, then my lord released. So my lord, early,
So it's a very difficult case.
yes, my lord. Length of hearing is required, my lord.
Length of hearing.
Yes, my lord. So another date may be fixed, my lord.
All right, when do you want it?
We wanted a, my lord, short date, my lord.
28, my lord.
2/8.
28, my lord.
First week of 2 I am difficult. Second week of November, any day also.
This is for hearing, isn't it?
Yes, my
So you choose the hearing date, Tuesday
yes,
or
my lord.
Thursday?
It can be on Thursday, my lord, 30th October. Then,
November.
then on 11th,
11?
11th November, my lord.
11th, no problem.
Anyone has difficulty on 11?
My lord, on 18th.
Post November. Post November also.
No, I have November না লাগে 11th হলে ঠিক আছে। Too long. 4th November হলেও ঠিক আছে লববারে। It may be on 4th November also.
Okay. As paid for by the learned councils for the rival parties,
Very so.
that the matter be listed for hearing on 4th of November. 2020.
Thank you. একবারে আগুয়াই দিন।
Okay, side of the issue. That is mistake.
Lordship,
Same day, Lordship, on
Lordship.
fourth.
on 4th, the matter may come.
Same order, huh?
Same.
All right.
Much obliged.
Oblige, Lordship.
Any interim order? No interim?
No.
Okay.
Oblige, Lordship.
My lord, on the last occasion, my lord, BTC standing council of BTC was directed to my lord, obtain instruction whether the scheme, when the scheme was discontinued. my
Who is
lord.
Mr. AK Bhuya?
Lordship, he is the senior standing counsel in the, for.
He is the new person
Newly
appointed.
appointed Lordship. So if Lordship can give us some time, we'll seek the necessary.
My lord,
instructions.
what that may be given, my lord, but.
How much?
My
How
lord,
much time will you?
Yes, Lordship, 3 weeks will be required.
3 weeks.
Moreover, Lordship, even I've seen that the counter affidavit has not been filed in this case by.
My lord, already affidavit part is gone, my lord.
No, no.
The last chance was given, my lord, in, my lord, to that effect, there is a order, my lord.
That,
Okay, so we grant time, they can file in the meantime. is that-
Lordship.
Mr. AK Bhuya, learned counsel has been recently appointed as the standing counsel BTC. And adjournment has been sought on his behalf for for preparing the matter. And arranging the case brief. Gustav as prayed for. Matter stands adjourned for 3 weeks.
My lord, date may be fixed, my lord. My
We will
lord,
list it
on
again also and so, okay, give it, date.
Yes, ma'am. 27
11.
November.
I'm
deeply
deeply
obliged.
Is that all? Okay.